That's what we are doing.
For admission matters, item number 2, Rohit Kovula.
Yes. Yeah, but trader is to not yeah, papers. Just now, no other day also. When you have served the papers? Yes. Huh? What is the difficulty? My name is not printed. Not necessary. The fact that you are here, you have filed a caveat, you are aware of the case, right? Yes. Then ends the issue. Yes. Proceed.
The order dated 11 and 15 that the current balance by an amendment introduced a new context is from 20
You are appearing for the bank.
Yes. Amendment
Pension scheme was introduced when, sir?
originally the pension scheme was from 11 sorry 4/11 covered
No, which orders? What, by which proceedings it was introduced?
and proceeding dated 11/11/2016.
11/11/2011. With effect from 4/11.
4/11
Then
was be administered to a trust.
what is a trust? Created by you.
Then on 15/9/2020, ADP, then Dubai scheme was brought into
With effect from?
the 1/4/2020. The minutes are
1/4? Okay.
the fast from this minutes is under challenge.
When they have retired?
Number of
2018. That is 15/9/2020. Right. Right.
Who were on the roads on.
What is the date of choosing that 15/9/2020?
The resolution of the everybody of the bank. Subcommittee appointment gave a report.
Is there the scheme differentiate between persons who have retired prior to 15/9/2020 and after 15/9/2020 or?
Yes, because it's a new scheme, a different.
More beneficial to pensioners. Now single judge directed that new scheme be applied to those persons also.
For those who retire even prior to 1/4.
No. 15/9/2020.
Resolution is 59.
Where is that resolution?
Start. Let's say 93 level.
What do you say about Nakara? Can you classify it? What do you say about Nakara, DS Nakara? Okay, we'll admit, we'll suspend that order. Right. It requires some examination. It requires some examination. Thank you. When you agree with the bench, you know the consequences, right? Right.
Said the people involved are only 120.
But still, it's a policy, no? We can't interfere with the policy. Correct?
No.
Can courts under 226 enlarge the scope of a policy? That's the point, right?
Clearly says that
We are aware of Nakara, that's the reason. Try to understand. Just what senior says, it is watered down in some other subsequent judgment, it seems, that has to be looked into.
By the time this reaches the victim, the restriction itself becomes infrastructure.
Why?
This is more about 70 years. So it can be 2 weeks, can be granted.
Okay, you furnish some security, bank guarantee, right? They'll release that. That will be subject to result of this writ appeal, right? You will be receiving all those things. You deposit your title deeds of your houses. Is there 1 minute? 1 minute. You are sir. 1 minute. You are entitled for pension. You are right. You are all 70 years. Correct. Justified. Furnish some security. You receive pension. That will be subject to outcome of whatever it is. Bank interest has to also be protected, no sir. Your only request is receiving money. That's all. That is what. What else? Then definitely every endeavor will be made to hear the case only. But still,
The thing is that only the people are involved, you can be heard.
There were two schemes, one in the year 2011, subsequently another scheme 2020.
but Delhi University judgment is also there, sir. What it says is CPF and GPF. Persons who have opted CPF and retired also. Still, what Supreme Court said is the thing which is more beneficial should be given to, they can, even after retirement, even after opting for CPF. If 1 minute, just listen now, what's the difficulty? Even now, if the GPF is more beneficial, they must be permitted to come under GPF. That's a judgment of Supreme Court. Correct. Then how do you overcome that? They'll also do that. Uh. 21? We'll suspend it. We'll hear after 2 weeks, right? Get ready.
Get ready, your lot. My happy with your pending, the date your lot.
Sir, even if you don't grant stay, they'll not implement because data bill is pending. Right? Right? Even if I don't grant stay, they'll not implement. Okay, notice before admission, post after 2 weeks. Anyhow, you will not implement. You will not press. Right.
After 2-3 years, already 20 of them have expired.
Come back to para 15, sir, of the judgment of single judge. Para 15.
Being mentioned is additional.
Adoni.
Scheme. It's the first introduction. I'm back.
We can fill the quotation. Notice before admission, post after 2 weeks, the respondent shall not press for implementation of the learned single judge's order. It's 1983. There can be a further classification between stated emissions. Yes. What is the case, sir? stability should be there, no, in the career. Otherwise, there's a point in just continuing. Eighteen years and 22 years and was
Earlier it was like that, not 8 years, 16 years, 24. Now it is 6, 12, 18.
what is that scheme? Automatic advancement scheme is there. Correct.
Here
Pass over, just get that scheme, we'll dispose of, we'll add
pertains to Ramesh only. This is
whatever
like-
it is. It pertains to one particular set of principles of law, right? We'll follow the law, right?
We'll inform you, tomorrow you know.
No. Pass over. ఆ స్కీమ్ తీసుకొని రండి సార్ మీరు లైబ్రరీలో కూర్చొని అది పడాల రామరెడ్డి సిరీస్ ఉంటాయి అండ్ ఆటోమేటిక్ అడ్వాన్స్మెంట్ స్కీమ్స్ ఉంటాయి దాని ప్రకారంగా మీకు ప్రమోషన్స్ వస్తాయి రైట్ అది అర్గ్యూ చేయలేదు కానీ మీరు సింగిల్ చేశారు కదా రైట్ seniors I think you can all shift in the front chairs so that so many people are standing. That's the reason. Please come here so that I don't want anybody to stand in my court at least. They should not make some arrangements. I don't like clients also, I mean, litigant public also to stand like that. Yes, maybe, but still. Yes. What is the stay you are asking? Suspension. What is it, suspension? RRD and General. Okay, notice. First of it, automatic admission. Notice. Counsel for the appellant is permitted to take out notice on the response. Equity shall be on there.
Item number 5, Srikanth Sridhar.
7, 8,
5.
7, 8.
Oh. 1 minute. 9 in and 25. Oh, what do you want? Notice, Amma. Counsel for the appellant is permitted to take out notice on the response. Post on all these cases on 2 weeks, right? 2 weeks, right? Next.
Item number 6.
Along with ఇంకొకటి చెప్పారు కదా 14 కాదండి ఏదో నంబర్ చెప్పారు కదా along with 431 first up with 431 of అది ఇయర్ చెప్పారా ఇయర్ కూడా చెప్పాలి కదా మీరు థ్యాంక్ యూ కరెక్ట్ నెక్స్ట్ no not possible 2 weeks. Right. Argue the case then. Why all this? Next.
Yes, either Madam Srinivas.
Yes.
It's on it. It's good pass. It's about it's fine. I think the nonsense. It was pass.
What do you say? Right, password.
I did my previous album, but right now. That is right. Never written love. इंफ्रास्ट्रक्चर करने को बिल्डअप करने के लिए कितने ईयर्स है कितना मिलियंस ऑफ डॉलर्स एस्टैब्लिश्ड they must spend for good purpose, not for destructive purpose or illegal activity. It's like the rate of which 2 million every time it's support. Extra dollar. I think a friend of very good days.
Yes, ma'am.
7 to 9 are adjourned, but 10 SR hardship, is the hardship.
ये 8 भी उसके साथ दीजिए मैडम. 8 ने 8 नहीं बोला. बोला 7 8 नहीं बोला. Okay. Yes. Love the papers.
I love that Mr. They said, no, client has gone away, so we'll have to issue notice to the market. I came here to represent staff. I serve my letter.
When do you want?
Next week.
Next Monday. Thirteenth is a holiday. 14th.
मैडम को लेके जाना रहता हूँ स्पेशल बच्चे बच्चों को भी लेके
Yes.
change of place it helps the family in a better way.
Then yes, ma'am.
I use grant arrangement leadership.
What is the suit for? Your IA is dismissed.
No, it's not discussed. It is constant.
You are the defendant.
Depending on
Then before arguing case, you must say, I was the defendant. All those basic, okay, right. You are an youngster, you are entitled. No problem. So in status quo is granted against you without hearing you. Right? Am I right? Notice, take out notice and we'll hear. Okay. Notice. Counsel for the appellant is permitted to take out notice on the response, right?
The joint position of yeah. जा रही एक work up ये बोल तो करना पड़ता है कि पहले ये करा अन्य admission तेरा सा साल बड़ा नहीं माने बस इनकी फाइल लगा है ना सर्विस से मन को मुझे नहीं पता yes बताइए
It's in the 20s, Praveen Kumar.
Notice, right? Counsel for the appellant is permitted to take out notice on the respondent.
and yes घंटा दिन तक तो बनी बेंच
Thirteen and 14, the Ramchandra Group in Rajendra Reddy, the Anthony Reddy.
Yes, where is Anthony Reddy? It got adjourned because of Anthony Reddy. Yes. You are Anthony Reddy. You are, what's your name? Huh? Balashiv. Okay. When do you want? No. 1 month not possible. Next Monday or next Tuesday. Huh? What's that? Is he contesting?
But these are small applications. The applications are first. Filing the application for the but respondent side on 4/8/2018. One application is about.
Or we'll do one thing. Get instructions from your senior on phone call whether these applications can be allowed or not. Right? Pass over. Pass over. LR application ఉందంటండి LR application somebody has filed. Set అది LR ఆటోమేటిక్ ఆర్డర్ అయితే అది ఎట్లాగో అది కావాల్సి వస్తుంది కదా 2018 లో చనిపోయారంట అప్పలెంట్ సో దే వాంట్ టు ఫైల్ సమ్ ఆర్డర్ 22 కదా అబెట్మెంట్ అయ్యింది కదా పాస్వర్డ్
order 22 in that application.
Sixteen Kalavar Sanchi, in Srikant Rao.
2 weeks right
See,
I know that ECIL right yes madam whether you have granted approval or what is you are supposed to get instructions OM of 2008 very specifically says that it comes with effect from 1/7/11/2007 and certain conditions are also there if the profit is less than 20% or something no so all those PSUs were directed to implement the scheme there is ECL is not running into losses. They come up with a scheme with effect from 2015. We have granted approval with mechanically without applying your mind. Right? We asked you to get instructions. What are your instructions?
In profit 24 hours.
26 November, 102 page number. EMI, what? Why you are just standing like that? 1 minute, Agan sir. Yes, Japan. How many times? How many times? How many adjournments it went? You please answer that. Third time. For understanding the case, how many times you have adjourned the case? To make you understand the case, right? First after 2 weeks. Okay, right. Amma, we are not interested in your counters. Respondents must apply their mind, DOPT, right? No, madam. Sir, 1 minute, such an option is given under 26th November 2008. No. If, 1 minute, just listen. That 26th November 2008 proceedings made it very clear with effect from 1/1/2007 if you are in profits. That whether the 26th November 2008 proceedings office memorandum gave liberty to them to frame a scheme with effect from 2015. No. It is running into losses. The question of applying the scheme at all itself is bad. 2015 के लिए చేసేది కాన్సెప్టే లేదు అక్కడ. Then why did you approve? 1 minute, madam. This kind of 1 minute, just listen. 2015 కెళ్ళి ఇచ్చే పవర్ ఎక్కడ ఉంది ఈసీఎల్ కి? మీరు అప్రూవ్ చేసే పవర్ ఎక్కడ ఉంది? అది లేదు కదా మీకు. There is no such clause. ఒక పని చేయండి సార్, ఆ స్కీమ్ నే ఛాలెంజ్ చేయండి మీరు. ఆ ఎంటైర్ స్కీమ్ నే కొట్టేద్దాం. మీరు స్టాండింగ్ కౌన్సిల్ అయిపోవాలి యూనియన్ ఆఫ్ ఇండియాకి. చాలా బాగా అడ్వైజ్ చేస్తారు. కరెక్ట్.
Which the same just said that if itself makes a people a loss, then team is not a people. Because this topic is made, ordinary people become I need to stop because that is their scheme itself.
We have been telling you them from past so many times. Still they are not able to understand what to do. Right. Next, first chapter 2.
I think another time I placed in an account of which I some people be అరే కరెక్ట్ అడ్వైజ్ అండి కదా, అక్షరాలు ఇదే కదా యూనియన్ ఆఫ్ ఇండియా అని చెప్ప స్టాండింగ్ అవుతుంటే పెట్టుకోండి. ఈయన పోస్ట్ ఈయన పొజిషన్ దృష్టి సొసైటీ పోస్ట్ అంటే స్టాండింగ్ కారణంగా రాసుకొని అది రాసుకొని
So 2023 కేసే కదండి, అప్పుడే ఫస్ట్ చాప్టర్ 2. Yes, 2 Ganesh are there. No? Same case. Ganesh is represented by 2 councils. Pay scales, correct? Huh? 2 weeks, huh? Okay, post after 2 weeks. What to do? We are not. Huh? We are aware of everything, sir. Next. They don't want to argue before this bench, perhaps.
20 because there was one stage with the family.
Where is Ramarao? Departmental proceeding, same case, kadandi? Post after 2 weeks, right?
21 cents.
What is the case, Samar?
Lord, regarding notional promotion given to the respondents, Lord, challenging that writ petition is filed. That is assistant executive engineers.
So that was writ is dismissed.
It is dismissed, challenging that, Lord, this writ.
Yes, sir. Post after 2 weeks, right? Next. Argue the case, sir. Next.
20 because 5%.
Both same.
Same matters.
Who is appearing for the contesting respondents?
Everybody is.
Right. Whether reversion, assistant engineer, assistant executive engineer, same case, no sir? Whether your probation is declared or not declared, same case, no? Right.
Your lordships heard the matters earlier.
Vote number must have changed, but right. Next.
23 is adjourned. 24, Mustafa Bashir. L. Krishna Kumar.
Post after 2 weeks, next. So what to do? Please tell us. No? We are also ready to hear. Sir, what is the point in arguing a case when the other side is not there? Right. Thank you.
25 is adjourned. 26, Chandrasekaran Law. Without.
You are the plaintiff or defendant? Okay, right. Is there any mental act? Okay, thank you.
After that, the father died, father then defied the school. That's the second law there. Mental certificate cannot be. Till the doctor is examined, they cannot accept the doctor. They just say you will get a different other institution cannot have taken care of the last 30 years. They are very jealous of property.
How much you got in this partition? Before decree, you enjoyed this property. One made said. By virtue of 4 gift deeds, you are enjoying 4 properties, right? Now, how much is the revised properties you got after this partition?
Six daughters.
So 1/6 share you got. Yes, who is your other side? Ready? Prepare a small synopsis, get ready, we'll hear the case. Post after 2 weeks. No, nothing. Next. Two weeks, get ready, sir. Prepare a small synopsis with page nation and page numbers, evidence avanni. I think we'll have to call for the floor. मैडम फर्स्ट अपील सुनने के लिए नीचे कोर्ट से आना ना रिकॉर्ड ఇక్కడ ఎవిడెన్స్ यहाँ है पूरे वो पूरा रिकॉर्ड को मांगेंगे पोस्ट आफ्टर 2 yes sir that's what we are 2 weeks 2 weeks అంటే 2 Monday huh? Nineteenth అండి 19th sorry 20 then 1st December right sure. No
కండిషన్లు ఉండేది రాపించుకుంటే చెప్పండి చేసుకుంటే వాళ్ళు
27 cents is really of this year.
Where is, who is what appellant? You are appearing for appellant? Okay. What's, is he, his appeal, no sir, he is requesting time, right? Post after 2 weeks, next. Provided he agrees and argues the case. Right. I don't know. Right, next.
Section 7.
Choose some, right, next. We said 2 weeks. What, you wanted what? 14th happens to be Tuesday. Next Tuesday. Next week Tuesday. What do you say, sir? 2 weeks, right?
28 minutes long.
Just wait for other side, right? Post after 2 weeks. Next. Huh? Limited stay on the children. This court will never grant any limited stay. Okay, interim is granted on 12/7/2023 are extended until further orders. Post after 2 weeks. Irritation. Only till then in that 1 year, I disturb now, 1 year extension.
Please be last.
Yeah, they, church matter. I think my brother's classmate or something last time, I think, same case, no?
Last time, that has been clarified.
Yeah.
Clarified. He's not the same thing.
Yes, yes.
That is, we are shifting from. Name safe should be safe, but.
Okay. Yes, madam?
Sorry. They are from.
14th. 14th November. Yes.
Of which the person pays 1/11 share. But the bill already exists of the person who was owning the property. That bill has not been charged. And that pursuant to that bill, the entire land has been given to one land. That person who has executed the development, registered development of the. I have constructed and I have constructed before it. But firstly, without challenging the bill, there cannot be a particular suit because bill is not under challenge. The person who has given the development agreement.
Yes,
My property. and-
understood. Understood, right?
I have 5 lakhs.
Understood the case, right? What?
I recommend that they-
Right.
Property in the way of- If really- Fight your right. On 21. Yes, before she died. Yes, she has yes, stated that. She can survey anything in the land of seven trade.
Whoever, will is of father. Huh? Arvind. After sale, after sale.
That one set of properties are sold.
Oh.
Now the remaining for the entire plot, the estate, they come up and set up the estate, like based on that allocation.
No, no, first tell us, sale deeds are prior. So that property is also included in the, then?
Now they set up what they have. Basic one
Hey, what, you have, no, one minute, you have filed a suit for partition.
Yes.
What is the share you are claiming?
But I am claiming for one level share. There are so many class 2 heads that I am only one of the class 2 heads. Admittedly, he is also not claiming rights to class 2 head. But one of the class 2 head, executes a development agreement with respect to one particular property.
But in the melee, because of your family problems, why a builder should suffer?
No, that these are been set up by that.
No, he has constructed the building, you never objected to it. Uh, uh,
There is a second part, they say,
Have they, any order is there that they will not claim equities, they will be permitted to proceed with the construction, but
expert said,
Oh. Oh. No, 1 minute. 1 minute, sir. Construction will not be over in a day or two. It must be going on since last. Huh? Oh.
Was on 22.
Oh.
But immediately when they started construction, we came to know
Oh,
about that.
yes.
Challenge is keep building permission granted.
Oh, then what happened? Then what happened?
Because no action has been taken.
Correct. Then what happened?
Initially, there was an order passed,
Hmm.
but it also got party.
Hmm.
Same that
What happened to the writ petition? No, please answer this.
directly conduct inquiry and decide on the building application.
Then what happened?
That was granted in our favor.
Hmm.
But that see that the director that God watch out by so
Correct.
that by you find a super partition.
Oh.
Lord, if the partitions you got to find an idea, but that's what the order which
Now, sir, but in the interim he has constructed, no.
constructing not knowing that
But what is the direction you sought for restraining him from constructing is the question we are asking. You have filed an IA that has not been ordered. Then you should have come here by way of
now there is
counsel. What is the question we are asking you? You have filed a suit for partition. Before that, we are trying to pursue your remedies by way of a writ petition. Writ petition came to be disposed of,
Yes.
wherein you challenge the building permission granted to the builder.
Yes.
Petition was disposed of, then only you came to know that you must go and file a suit for partition or whatever it is.
Let the bill date be decided, no? Whether it is fake or not. Let the bill date be decided.
you got to pick this not challenge. Not will they have the not challenge. But they have established that but it's a valid case. But it is they who are relying on that bill. But according to me, there is no bill at all. But now they have set up this bill. It is burden of proof placed on them to prove that the bill is executed by them.
What is the nature of property?
It's about properties here. One of the properties now not by Lord is Lord house. Understanding it, what is Single is called bill is not challenged, law is bill is not be registered. Unless bill is challenged, they cannot ask for any of these players.
But they are also not aware of the existence of will. No?
It's on record. It is on record, it is on page 414. When the bill is at page 414, it's on record, they don't challenge it, they choose not to file a suit against the bill. They know it is gen-based. They just simply file a partition suit. That also 110. There are 10 apartments. Even if they win that case, they will get one apartment, half an apartment. But my 5 apartments are landowners. My 5 apartments are builders, why should they not be told? I ask myself, even if they win the suit, they will get half an apartment.
You get instructions. No, right. That's right. You get instructions. Correct. No, right or wrong, somebody has invested his money and constructed the property. No, that's the point.
Registered, alert, ATS, you are documents.
No, 1 minute. 1 minute, sir. Right or wrong, you allowed the constructions to go on. You were not, 1 minute, just listen now. The moment injunction should have been granted, restraining them from constructing, correct? But by the time you got this order, if on the first day itself you don't get an order, you must come up before this court, higher court, saying that my injunction application is pending. Let the court below be decide the case within 1 week or 2 weeks. But you must not allow that construction to go on. Now, what happens if the construction is already proceeded, completed? So it must have taken 1 year or 1.5 years, no?
All happened in 6 months time, so that's what we learned. It's an apartment, it cannot be completed and got there so fast.
That's what we are also surprised. How it has been completed.
Instead itself, there is an order in my favor by the requisition. Then
First of all, you had forum hunting kind of a thing you did. What is? No. You tried in a writ petition, failed, disposed of. Then at that time you sought liberty to file some suit. No, you don't require any liberty from this court under 226. What is? No, 1 minute. 1 minute. There is a question of 226 court granting you liberty to file a suit. That is always goes, the moment you are a citizen of this country, you are entitled to pursue litigation the way you want, based upon the advice given by legal counsels, correct? Yeah.
action is completely different.
All your contention have gone, that fraud and all those things, no? They have obtained building permission with fraud and it could not be established, no? Inquiry was conducted with the commissioner, he has held that the permission is valid, right?
But they only said we will not look into
Well, that's what, naturally, you are also aware of it. Because, post,
now.
what happened to the writ petition? Get instructions, when do you want? Huh? Next week, okay. At the request of respondents, post after 2 weeks. Because, right or wrong, he has constructed.
He will not even get one flat. Let the person, my flats are.
No, 1 minute. It is not only the plaintiff, everybody becomes a plaintiff. You know, the defendants also become plaintiff in a partition suit. What is? Right.
Out of the 5 landowner share, from builder share, they will anyway not get.
No, again, who are the owners? No, 1 minute. You are claiming title through whom? With the way, where is the original owner? 1 minute, just listen now. Where is the original owner who has entered agreement of sale with you? An agreement of what is a development agreement? All right. Who is appearing for him? Okay, we'll order notice. 1 minute. 1 minute, sir. 1 minute, sir. Arjun is appearing for that. Okay, get instructions. Post after 2 weeks. You also inform that Arjun, so that we can. Arjun name is not printed, but. Again, notice, notice counsel for the appellant is permitted to take out notice on all the respondents. Right, post after 2 weeks. See, that's what, let it come after 2 weeks, right? No, we'll have, no.
Because of that after independence, only person was filed as in this person.
1 minute, sir. In a suit for partition, even defendants also have we have plaintiffs, no? Kind of a thing. Yes, everybody should be. Then we will dismiss your CMA only on that ground. How can you say that others are not necessary parties? Right. No.
I mean, the person was registered to say development agreement is support. That is what you're not.
We want to hear him. Right. We would like to hear everyone. If we say that others are not necessary parties, then we'll dismiss this CMA. Thank you. Thank you then. Thank you then.
The bill today is not under challenge.
Whatever it is.
But if the bill is not under challenge, the suit is not.
First, remove that other persons are not necessary. Right. Thank you.
Right, right. You will have your son, and then the term will just go. But in that, like, you leave no connection, and that we will not, but,
Only one. You also get some pragmatic instructions, correct? Let the plaintiff and other class 2 legal aids, they are 5 in number it seems. You take one flat something so that the entire issue can be resolved. Right. That's the reason. Right. Work out something, pragmatic way. Right.
All this bill was also, we have some kind of production.
Don't know anything, sir. Next.
Be given this.
Correct. Next. Right. Next.
responded by lady, we enter into a which are the later culture.
Right.
Okay, so, that's interesting how.
Property to the million natakal చేస్తారు brother sister
Yes, sir. What is the case? कौन सा केस बुलाया मैं 31 okay you are appearing for earlier case you are opposing him no just 1 minute our memory is something sir just 1 minute that bank what is that bank case item number 2 okay yes
Pending the suit, an application for injunction was sought for. The trial court granted an injunction in respect of scheduled F and scheduled
Hmm.
property, not to alienate.
Hmm.
In respect of the other schedules, the court rejected it.
Hmm.
And before this court submitted to, even in the counter, it is admitted it's a joint family. Even that extent of property is important to grant. The court may kindly see.
First take as it rejected in respect of suit schedule property of which F and G.
All the other property the court rejected.
Where is it schedule?
Even at the
70, 60, right 1 minute.
Yeah.
Starts from 60, I think. 60, 59.
starts from the 26. Yeah. Thank you. 837. Yeah.
Because in respect of 1 minute, sir, in respect of something, Surface Act was holding the field. How? Hmm.
We got the lease from surplus of salary. Secondly, business for over 40 years.
Hmm.
And properties were purchased in name of one or the other, sometimes joint deals. And difference of opinion came to property was filed. As we tried to develop all the problems. Court granted leave in respect of two properties. In respect of other properties, it rejected it from the ground. No proof is filed. That is contrary to the very context, what I am trying to point.
Yes, who is appearing? You are appearing for which respondent?
Father and son. whole fire, whole effect. How is it to happen in property even in the name of the company? Nothing is for the part. I frankly saying about, I'm not supposed to fabricated the signature of the father. In MOU, instead of filing a specific performance, we file a super partition. India is claiming 40, 20 plus, apparent 40%, others are 40%, father 20%. If fabricated signature, especially, they have been taken. For all the, it was not at all normal, it's the document.
Properties are in the name of whom, sir?
Some are in father's name, some are in joint name, street properties are in the name of late mother, who father in estate. They become joint properties of the family.
What is exhibit R3? The letter given by stamp and
If settlement deed, amma.
The stamp and the race is that he has never sold the stamp. True. Stamp and the patent never issued. As if stamp paper was sold in favor of that. He not his original signature.
Letter given by a stamp and the millet, they say that no stamp was been issued by him. It was also marked.
No, 1 minute, 1 minute. What is your instructions? You are willing to sell away the property or? No, that is a different thing. 1 minute. 1 minute. He is seeking not to alienate. What is your instructions? You want to alienate or you don't want to alienate? What is his intention? Kanukkon Randi. 1 minute, Kanukkon Randi, next Tuesday, okay? Next Tuesday, sir. Right? 1 minute, sir. 1 minute, sir. Get instructions whether he intends to alienate or not. Otherwise, right? There is an innocuous order, right? We're fair in 2 weeks. Let us get 1 minute, sir. Let us see. Right.
Therefore, thing may happen.
Nothing will happen. Don't worry. Next. No. Let us see. Chandrasen, ask them not to precipitate till you get instructions.
Stamp paper is.
So what is the stage of case, not to alienate and value job? If he is not willing to sell anything, అది చేయొచ్చు కదా till the disposal of the supply. అంటే మనం మెరిట్ ఎందుకు స్టాంప్ పేపర్ చెప్పి అన్ని డిపాజిషన్ లో మనకు పోయేది అవసరం లేదు సూట్ లా కాదు.
If it is a fake one, then we will need to pass on.
ఇప్పుడు అబ్జర్వేషన్ మనం ఇక్కడ రాసినాం అనుకో సూట్ అఫెక్ట్ అవుతుంది. ఏదైనా అడ్జుడికేషన్ మనం అవన్నీ సూట్ లో చేసుకోవాలి. ఏది అది ఇప్పుడు ఇంటర్లాక్ వచ్చే అప్లికేషన్ చూసేటివి కావు కదా ఇష్యూస్.
Various of the case will get government even patent.
పే కంటే మరి సూట్ అయిపోతుంది.
Okay.
కానీ చెప్తున్నా
Correct.
కరెక్ట్ రాంగ్ కాదు అక్కడ. వాట్ స్టేజ్ యూ మస్ట్ టాక్ అనేది ఉండాలి. ఇప్పుడు ఈ ఫాదర్ కమ్స్ అండ్ సేస్ ఐ డోంట్ వాంట్ ఓకే ఐ యామ్ నాట్ ఇంటెండింగ్ టు సెల్ అన్నది. సో దేర్ ఇస్ ద ఇష్యూ కదా. సింపుల్ కదా. I intend to sell it on it. Then one must go into all this. అప్పుడు ఏమవుతుంది? పాయింట్ ఆఫ్ లా మీద కూడా ప్రోడక్ట్ అలా కూడా రాసింది. Yes. 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 All these things ordered, madam, right? All petitions ordered. Did a good job. Argued well. LR application ordered, amma, IA 3 of 2023. Set aside abatement 2 of 2023 also ordered. Condone delay, what's the delay, madam? Okay, there is also condoned, right? Yes, madam.
been filed against the deed of LA 41 and such. So this another connected matter. There is an order which is passed granting stay allowance. This matter they filed a stay pending. The stay may be granted subject to some deposit of 60%. Also finally take a look at the
Questions, these matters transferred from Aguirre or the Madrid, right? You have to be constructed on that. So we take it.
Fair enough. Right. Stay application, but just 1 minute, madam. Stay application next Tuesday, right? ये 1 of 2023 audit, 2 of 2023 audit, 3 of 2023 audit. ये 1 of 2020 post next Tuesday. Right. Next.
ఇంత ప్రిపరేషన్ చాలా ఇంత మంచి వేస్తే ఏమంటావు లైక్ విషయం కాబట్టి ఇచ్చేయచ్చు పైసలు వాడే ల్యాండ్ వాడని ఇంకా చిన్న పిల్ల చాలా రేట్స్
Yes.
My lords, in this matter, lordships, we filed the appeal lordships, wherein lordships, R6 is died lordships. Respondent lordships filed a memo lordship saying that the illegal is against details lordship. He will take steps lordships may grant sometime lordships to bring on the liquor.
The LR petition control the for R6. Maybe so that he may not.
Yes, yes. Anybody can, under order 22, anybody can file.
My lords.
In look at the same 1 of 2023 audit, 2 of 2023 audit, 3 of 2023 audit, right? What do you say about the main appeal?
Lordships may grant some time, 4 weeks time lordships we will hear the matter.
There is no assistance from your officer. You said you'll dispose of. Huh?
Lordships.
Appeals can be disposed of in the path.
Yes, yes, I love that we will.
Post after 2 weeks. Next.
My lords, so one is lordships, we government filed appeal lordship, one is lordships, other side is filed lordships. Lordship it is coming up for lordships, so finally hearing lordships, lordship may put it for finally 2023 matter lordship.
If that is, that is all the papers that is sanctioned or not taken. But still,
Okay, post after 2 weeks, right?
only legal point. Illegal.
Who is your other side? Ready?
Lordships may grant sometime lordships because 2023 matter lordships, so they are for finally.
You are appearing for Singareni College.
Some of them.
Same consideration you will show to your. No, no, not arguing. Same niceties will be there when you are arguing for Singareni College. No. What definitely? When it comes to you, elderly lady, all those things. Other side, when you appear for Singareni College, nothing. Only black coal. There is a saying in India, I think. कोयले के धंधे में हाथ तो काले ही होते हैं. Yes, sir, when 70-year-old appellant is there.
GP requested sometime lordship.
What is the compensation awarded by the LOP? Huh? Per acre. Correct. Then you want it? Which area is that? City? $50,000 is, huh? మేరీపట్నం అక్కడ ₹1,00,000 ఉందండి ఇప్పుడు ఇంకెక్కువనే ఉండొచ్చు కదా 50,000 is reasonable.
Legal point, escalation, cumulative escalation. And two exhibits.
Registered sale deeds ఏమన్నా విసిల్
Residential only for the reason that it does not reflect our land value. Further, the both the government and 100 FFP structure is there. But if that is included in the rest of the profit, that's the value of the document is taken for the.
Yesterday, day after tomorrow, 70-year-old.
Big logics.
Why?
GP is requested logic. That's why.
మేము కూడా రిక్వెస్ట్ చేస్తున్నాం జీపీ వచ్చి అపియర్ కమ్మని.
Logics, sir.
Huh?
Because next week logics.
నెక్స్ట్ ట్యూస్డే రైట్.
Every 7 minutes, 7
My lord, appearing virtually, my lord, for the petitioner.
Yes. What is the case? What is the case, sir? What is the case? Within the Vanjari community, same case, it's covered, I think. Yes, including this community, deleting. Correct. So that is not his fault. At that point of time, authorities were issuing Vanjari community as SC certificate, SC certificate. Correct, when it was invalid. Erroneously included, but still. A state could not have included. It is a president who must do that, right? ఏమా మరి ఏం కేసు ఏంది చెప్పండి. It's a case of, it is a case of removal. What is the date of removal? The writ petition is liable to be allowed. We are aware of it, right? Saying, what is the age of this person? Then we will set aside that order of removal. ఇంక్లూడ్ చేసారు పార్లమెంట్ ఇంక్లూడ్ చేసేదానికి ప్రెసిడెంట్ చేయాలి కాన్స్టిట్యూషన్ ప్రకారం 1950 అది రియలైజ్ చెప్పి అది విత్డ్రా చేసుకున్నారు. బట్ ఆ మధ్యలో ఎంఆర్ఓ సర్టిఫికేట్ ఇచ్చింది ఎస్టీఎన్ బేస్డ్ అపాన్ దట్ యూ గాట్ ఎంప్లాయిడ్. వన్ ద ఫేమస్ అర్థమైంది. Compulsory retired. Huh? It was compulsory retired. It was compulsory. అంత డిఫరెన్స్ ఐడియా వస్తాయేమో మీకు. దట్ యాటిట్యూడ్ that I am superior in attitude చాలా ఎక్కువ ఉంటుంది సెంట్రల్ గవర్నమెంట్ ఎంప్లాయీస్. కరెక్ట్. దట్ I am everything. I am the correct. How can compulsory retirement can be enhanced to remote? Why not dismissal? By what GO it was included and by what GO it was deleted, madam? Uh. 44 it was deleted. Date 23, when the caste certificate was granted to him? మీ డేట్ చెప్పండి అమ్మా. మీ డేట్ చెప్పండి అమ్మా. This petition is filed. Yes, sir, you want to say anything? Shravan? One madam, technician, I नहीं आ रहा. Trying to say something. Hmm?
Sir, we are not just for the sir. Your voice was checked.
కోర్ట్ కి రండి మీరు 2:30. Next. Case dismissed. Then he'll come rushing to the court. Next. Passover, come at 2:30. Otherwise, next Tuesday. Right. Whether both can be accommodated. Yes,
Lordship, Dayakar sir requested for a passover.
Passover. Right. What is the post? Why it was cancelled? You are unofficial. You have succeeded before the time. You have succeeded. That's what you are for the response. No? Why is this allowed? Why- Then why did you file? Why? What is the second case? Acha, government. So your appointment was set aside. Your OA is allowed. On the ground that you are more meritorious than contesting this. But prima facie, tribunal felt like that. Right. Pass over.
Yes, we-
2 weeks. Right.
40 minutes.
Same peons working in that LIC, same thing. What happened to that contempt? Preferred contempt appeal? What happened? Stay on my order. Huh? Where is it order of granting stay? Huh? Elaborate order or just? Password. Post after 2 weeks, right? Next. No, not possible. No, 2 weeks, right? Okay, IA 1 of 2023 for the reason stated therein it is ordered, right? Post after 2 weeks, next.
Copy 8 to 50 Srinivasarao Madhya.
What is the case? Siddhareddy's case. Post after 2 weeks. Next. Up to 50, madam. Right.
Every number.
Post after 2 weeks, next. हमारा वही कर कोई आगे से भाई. Post after 2 weeks. Yes. That lower pay scale came to, on request he was reverted. Liable to be allowed, I think. That's what we told you last time also. Some, yes. Office memorandum clarification DOPD has given, saying that how it has to be. No, same case, no? Yes. Yes, it's an issue of, no, it is technical resignation. Right? Page number something. Oh. No, all those things, page number 44, these words you are trying to use, that lean and all those things you are trying to incorporate, when it is clarified at page number 44. Oh.
So what you are to extend now regular basis only. I posted regular basis. Not my exactly. That is a case for the transfer. Not the case of the transfer.
Where is your rejection order? Please show us. We need it. We have put black specs. Yes. 66. Anurag, page number 68, following that office memorandum clarification, we have given him. It is only audit which has raised objection, correct? All right. No, no. Then why did you give? Why did you give? Right. Okay, where is that rejection rectified? Why it got adjourned to today? We have heard this case. Huh? Right. Where is rejection?
Not in my 66.
Huh?
66.
There is not the rejection order. What is? Okay. Yes, it is. Where is the rejection order, sir?
And Maratha 65 also Maratha. Because the Maratha.
Also, Kadandi, where is the rejection order? ఇక్కడ కూడా ఇచ్చేది. 66 లో కూడా ఇచ్చేది. That is 66 also you have given. Now, 1 minute. You have given extended benefit in terms of office. All right.
47 is the Maratha.
ఒక 92 అంటారు, ఒక 42 అంటారు. What is it, sir? ఏం సారీ?
47 is the Maratha. It's not. Because Maratha charge. Maratha.
And it's in that 40. She's on the ground. She's constructed to Maratha. At least it's not as Maratha. I got to the source of Maratha coming to.
రెండు ఒకటి అండి 92 ఇంకా 40 is. ఎక్కడండి ఆల్రెడీ రిప్లైడ్ అన్నారు. ఇంతకు ముందు ఏదో రిజెక్షన్ ఏంటో అది చూపించండి. This is not a rejection order. Already it was communicated and it was rejected. Huh? Sir, any problem? Any problem in understanding this case? Page number 60 is what? Where is this case rejected? Please answer that. 60 is not that. 60 is to Survey of India, communication by Under Secretary. Correct? Where is the rejection order? That is not rejection order, no? You are not able to tell us the rejection order and you're trying to argue a case. Huh? What is? Any problem in understanding the case? Please answer that. Where is the rejection order addressed to you?
By forwarding again to me. Not by way of Maratha the rejection. This is what I repeat Maratha my indication for area. How there is no way.
Where is that earlier rejection order? Where is it? 92 and 47 are one same. Right. Read. Why you are sticking to 92 but not 47? Right. Right. Next. Where is the point discussed? Please answer that, no? Why? 1 minute, sir. That could be his prayer. What is your case? Where you have adjudicated that is not entitled for this? Where is that adjudication? 1 minute, sir. Come back to page number 47. Read slowly with reference to above cited letter, reference number 1. What is that above cited reference 1? Is your letter dated, there is letter dated something, 9 December 2009. It is apprised that the subject case has already been referred to DOPT through Department of Science, Technology and Advice, Director so and so. Second read above. The concerned individual has already represented to all the channels and has been accordingly replied. That reply somewhere it should be reflected in the references, no? It is not, right? Call that officer. Call that officer who is responsible for this. What is this kind of assistance to the court? Already replied ante ikkada reference lo refer kavala ledandi cheppandi. This is how you pass orders, administrative orders. Administration is for transparency, correct? Not to confuse people like this, correct? I have already replied, I did not reply anything. What is this kind of argument? Sir, it is addressed to whom, sir? Why it was not addressed to him? Because you are dealing his representation, no? So you don't have to communicate anything to him. Where is it? 1 minute, sir. Come back to 56. Confused, slow, we have all become very masters, I think. Correct, read 56. First read, first paragraph and there. So you have recommended his case. No, come read. Reconsider. It's not a case of rejection, no? But why you are pointing at 56? Just now you have drawn our attention to 56. That's the reason we are reading 56. No, otherwise, why would we? Huh? Where is that rejection, please? That's what we are asking from that time. Where is it? Where? Page 47. 47 says what? Huh? 47 చదవండి సార్ మళ్ళీ ప్లీజ్. Where is it replied? It's a question we are asking from that time. If you have replied, should it not reflect in the references? Come back. Last sentence. Now there is no merit in the case to forward again to the ministry for consideration. Correct? So where is the application of mind that 44 office memorandum is taken into account? He is not entitled, lien, all those things. Where are those things communicated to him? Administration should pass how orders, sir? Please tell us, no? Enlighten us, no? 89. Yes, read.
On going to representation dated 10/9/2008 for Tata Rao,
PDC of Southern Printing Press.
Page 18. అది ఆయనకి ఇది కూడా ఆయన కమ్యూనికేట్ చేయాలి కదండి.
They also in my.
Huh?
They also in my favor.
That key communication is also there. The other signs of.
అది ఎక్కడ ఉందండి? దిస్ మీరు ఎలా ఆర్గ్యూ చేస్తున్నారు? అట్లా ఉండాలి కదా. ఇట్ షుడ్ ఇంప్యూటెడ్ ఆర్డర్ షుడ్ స్పీక్ నో లీగల్ పాయింట్స్ అక్కర్లేదా? యూఆర్ ఒపేకా, యూఆర్ అబౌవ్ లా అన్నా. And then office memorandum at page number 44 is not applicable to you since you are not a regular employee. All those things, where is it, sir? It should be considered or not considered? Huh?
We have considered speaking order.
Where is it? That's what we are asking.
That is at page 89.
Then it should be communicated to him, no?
So through the grievance, public grievance and redressal, so and so to Mr. Suresh.
So it should not be addressed to him.
It is communicated to him. Therefore,
Where is it a communication?
his communication was only challenged before the tribunal.
That is 47, not this one, no?
Subsequent 25 to 2009. The understanding of the opinion is the case of Tatarao does.
అవునండి, ఎవరికి ఎవరు అడ్రస్ చేసుకుంటున్నారు? మీరు చేసుకుంటారా? కన్సర్న్ పర్సన్ కి చేయాలి కదండి. టు ద డైరెక్టర్, సదర్న్ ప్రింటింగ్ గ్రూప్, సర్వే ఆఫ్ ఇండియా, హూ ఇస్ రైటింగ్ పబ్లిక్ గ్రీవెన్స్ అండ్ రిడ్రెసల్ ఆఫీసర్. దిస్ ఇస్ ఆల్సో ఇన్ హిస్ ఫేవర్. దట్స్ వాట్ హి సేస్.
Third paragraph.
Huh?
Third paragraph, it is referring to Marat OM 14/2006.
That's what it is not falling within the case of FR 15. Understanding of the opinion, the case of Tatarao does not fall under FR 15A. FR 15A is regarding to cases which seek for a transfer at his own request or request of the government. He does not fall under the case of a transfer.
Sir, 1 minute. ఒపీనియన్ ఇస్తారా లేకుంటే లీగల్ పాయింట్ చెప్తారా? ఈజ్ ఏ ప్రొఫెషనల్ టు గివ్ ఒపీనియన్. 1 minute, sir. Public grievance and redressal officer, survey of India, is giving opinion. The undersigned is of the opinion. Then the opinion is, you must say whether he is entitled or not. Opinion, what is opinion, sir? We are not able to understand. Is he a professional to give an opinion? India Japan, sir. Now his case was referred to DOPT, correct? Where is the DOPT's clarification? Yes, Public Grievance and Redressal Officer, Survey of India is giving opinion. Where is it? DOPT ఎక్కడ ఉందండి? No, you said you have referred his case to DOPT, no? ఇదే కదబ్బా పేజ్ 44. Sir, where it has been referred, please answer no, sir. We also don't like asking how many times same thing, repeat. Password. What will happen tomorrow? Nothing. You are saying so many things, it should be reflected from the papers, no? 19? 1 minute, sir. In 2006, OM is there 14 to 2006. 1 minute. When it is clarified in 2006, how can you fall back in 1965 OM? Who said so? No, sir. 1 minute, sir. 1 minute. You have fixed this pay as per 14 to 2006 at one page. Audit has raised an objection. You have referred to DOPT. DOPT shows the answer. That is not entitled. On the other hand, page number 89. Your Survey of India says that in my opinion, Office memorandum dated 14/2/2006 is not applicable. Who is it to give his opinion when you have referred to DOPT is a question we are asking you. Please answer that. That's as simple as that. Still understood or not? Thank you very much. Where is DOPT's clarification? At page number 1991. That is Anurag's contention. Just 1 minute. Where is the department contentions and recording and dealt his case by applying mind? We are entitled to. Thank you.
Whether it's a case of a transfer of it is not a.
Sir, 1 minute. 14/2/2006, you have extended 1 minute on your own. Since audit has raised an objection, you refer to DOPT. Right or wrong, please answer that. Where is the DOPT's clarification? You read. One minute. Yes. Whether this was communicated to him. Where is it? Which page is that? What is the date of that proceedings? DOPT? OAs of 2010 and మీరు ఎట్లా మాట్లాడతారు సార్ మీరు సార్ OAs of 2010 కదా సో మీరు 2012 proceedings DOPT clarification చేసిందని in anticipation DOPT would be clarifying like this and మీరు already pass చేశారా చెప్పండి సార్ నువ్వు అంటే మరి మీరు చెప్పారు కదా ఇప్పుడు DOPT లెటర్ అండ్ డేట్ of DOPT. No, just now you read something, no? అదే కాదండి డేట్ ఆఫ్ దట్ లెటర్ DOPT. Just now you said 12 కదండి ఎక్కడ ఇది కాపీ ఉందండి మీ దగ్గర ఇంకొకటి చదవండి సార్ ప్లీజ్ పారా 3 కెళ్ళి చదవండి వేర్ ఇస్ దట్ అర్లియర్ రెఫరెన్స్ ఏది ఉందండి ఫ్రమ్ దట్ టైమ్ వీఆర్ బ్రేకింగ్ అవర్ హెడ్స్ నో వేర్ ఇస్ దట్ అర్లియర్ రెఫరెన్స్ అనేది
It was advised to the Ministry of Science and Technology to amend the draft to bring out policy and decision of the government rather than view of the individual department. However, it has been observed that in the amended draft reply also specific name of the department, Department of Personal Training, has been mentioned at para so and so. Further, it has been observed that this department had earlier advised its UO and
ఇది ఎవరు ఇచ్చారండి
Deputy Secretary.
Third para lo, the case of Tatarao is examined and this order dated so and so. We have given clarification and ఒకటి చదవండి సార్ when it has been referred to DOPT.
Which actually Tatarao needs to be fixed under FR 27 in terms of office.
అదంతా మీరు కథ రాసేస్తున్నారు బై విచ్ ఆర్డర్ అనేది చెప్పండి సార్
OM 1965 OM is what is applicable.
1 minute sir. When there was a confusion how Tataro's pay has to be fixed on the audit objection, you have referred the case to DOPT. From this letter also, by what proceedings DOPT has clarified, okay, cheppandi sir, please. Adi chadvandi malli enduku why you are shifting the pages, right? Adi dintlo show us a date that DOPT has clarified why proceedings dated so and so. DOPT has examined the case of Tatarao and Even this clarification, white proceedings dated and look at చదవండి మీరు. Para 3 చదవండి sir, please read. You are just wasting court's time.
There is my counter at page.
అంటే దీంట్లో అక్కర్లేదా? అంటే డిఓపిటి క్లారిఫై చేసింది ఎక్కడుందండి?
DOPT clarified 1965 one is applicable is what DOPT clarified.
Why, what proceedings?
Proceedings is not mentioned in this case.
And this is how Government of India functions. Government of India functions like this. When it has examined the case of Tatarao and it has given clarification while proceedings under the, where is it? Who is this deputy secretary who has issued letter to you? Ask him to be present. Right? What is? Is just taking things for granted.
Page 15, 16 and 17.
Are you aware of Mohinder Singh Gill's case? Huh? Can you give supplement reasons in a counter?
Proceedings of the.
Huh?
The proceedings only in my counter I referred.
What is the date of that counter, Shepherd? Proceedings?
Proceedings dated 23/2007.
That is not communicated to. We are repeatedly telling you the same thing. 2007 proceedings is an internal communication, not communicated to him, right?
Not communicated because it's only a clarification grievance we saw it.
No.
It's communicated to him.
Then how can you reject this case?
We saw it, but my pay has to be fixed.
Page, 2007 is at page number 40. Two 2007 proceedings, where is the clarification? Huh? 60. This is a so-called DOPT letter, and 60.
This is a communication. My counter may be taken.
1 minute, we are not interested in your counters. Please, 60 annaru, please look into 60.
60 is regarding to protection of pay.
Where is the DOPT clarification 2007 annar kada?
DOPT has advised to fix the pay. 4/1/2007 third line. DOPT has advised to fix the pay of the Tatarao FR26.
Sir, 1 minute, sir. Page number 60. Every time, whenever we are hearing this case, same thing is happening. Other day also, 1-2 hours we have spent like this. Right? Now come back to page number 60. DOPT has advised to fix the pay of Sri Tatarao under Fundamental Rule 27 in terms of Office Memorandum dated 17/6/1965, copy enclosed. Where is that copy? Subject to fulfillment of conditions. The issue before the DOPT was, just listen, sir. The issue before DOPT was whether 14/2/2000 Office Memorandum 2006 Memorandum applies or 1965. It should clarify. Now, DOPT cannot advise to fix his pay in terms of FR 27 without examining the case, whether his case falls under
7 or 22. FR 27 or 22 in lieu of FR 15.
FR 15, that is Office Memorandum dated 14/2/2006. Right? Where is that clarification from DOPT? Applying its mind that page 44 Office Memorandum applies or 1965 OM applies. That should be clarity, should be there, no? Because we have extended the benefit of 14/2/2006 in favor of this person at granted some relief, right? Now you want to take away by referring his case because audit has raised an objection. You have referred to DOPT. DOPT should clarify whether 2006 office memorandum applies or 1965. Where is its application of mind and where is its order? Right? What yes?
A clarification, I'll just ask, no, it is not in detail, but they have just informed you stating.
You are a government of India, a state. It should be in detail, I think. Huh? You are not above law, right?
One 15, 15, they just, you know, just a 27. But 27 is not.
15 under fundamental rule 15 in terms of 14/2006 you have extended the pay. Then you say 22 will apply. Then you say FR 27. Which one applies? You tell us. No.
Now your case is.
Huh?
I just put forth my contention. It is not a case of a FR.
We are not interested in this kind of contention. There should be a clarity, right?
The clarity it was put forth. I just what was raised before the tribunal, whatever my contention, my limited things to the record is that he does not fall under FR 15 because it is not a case of.
He falls under what is the question we are asking him?
Falls under FR 27, which reverts back to 19.
But at some proceedings, you also said he falls under 22 also.
22 is what his contention is, my lord.
No.
FR 22 is what was his
Okay.
contention.
We'll search the paper and say your case was FR 22 applies. We'll definitely show some document.
27.
1 minute. అది ఎక్కడ ఉందమ్మా 22 ది ఎక్కడ రాసి వచ్చు.
Page number 46 is what, my lord, I was referring to the other day.
1 minute.
Mural, page 78. Page 78. And the counter which you have, the reply which you have filed before the tribunal, you say case was referred to DOPT through the nodal ministry and DOPT advised in this particular case. Court wants to know what is the advice which has been given by DOPT. That's all. It is your own counter. Just
My reply.
that is the only point.
Reply before the tribunal.
Because in the counter, you are saying that 15R doesn't apply, then 22(1)(a)(3) doesn't apply. It is 27 which applies. But there were letters which were written by the Survey of India also saying that 20TA13 has to be taken into consideration by fixing the pay. Now you want to say by keeping examples of other Shadangi and Shailaja who are transferred to a lower case, there you are using 22A13.
That is their case.
No. Even then,
I'll clarify.
so that is the point which you are trying to stress now.
That is the entire distinction I want to make is that they were all people in the same department.
At least a DOPT clarification should be there, no, when you have written.
That DOPT clarification, I'm not.
Because your office cannot give a clarification, which is sitting on the same question where a representation has been made. It has to be given to an authority which has to fix it properly, right?
That's the reason.
In your counter, you say advised, but you don't say.
Otherwise, I'm not able to point out, but their case is what was referred was.
No,
that
we
they-
understand the case, but we also have to see how DOPT has answered it. isn't
DOPT
it?
has answered.
You cannot answer your own case.
Come back to 89. This is Survey of India. Read. Yes, from the beginning.
On going through the representation dated 10/9/2008 of Sri Tata Rao, UDC of Southern Power Printing Group Survey of India, Hyderabad, regarding his fixation of pay in the lower post while transferring from higher post at his own request. It is seen that the office has initially employed as stenographer, officer was initially employed as stenographer grade in the office of so and so, Ministry of Defence, Delhi, in the scale of 4,000 to 6,000, effect from 15/1/99. Due to his selection for the post of LDC through SCC, he joined Survey of India, Hyderabad, on 10/5/1999 for getting his transfer to lower post in the scale of 30.
So just now you say it's not a case of transfer అన్నారు. కానీ మీరే చెప్తున్నారు కదా మీ ప్రొసీడింగ్స్ లో ఇట్స్ ఏ కేస్ ఆఫ్ ట్రాన్స్ఫర్ అని. ఓకే చదవండి.
Going through the representation, his representation is as though it is a transfer. He said that it is not the case. It was
చదవండి
a
చదవండి అది మీ ఆఫీసర్ రిఫర్ చేస్తున్నారు కదా.
The officer served the parent department for a period of 5 months approximately. Therefore, he is not entitled.
So you complete that by getting is transferred to lower post. చదవండి after technical resignation from the post held.
Getting is transferred to the lower post in the scale of so and so after technical resignation from his post he earlier held. He held earlier.
So these are all on the representation of so and so. These are the findings you are giving. Correct? This officer is giving.
Grievance.
Grievance కాదు.
On going through the representation of so and so regarding the fixation.
Page 84, come. It is in Hindi. Read. I'll read partly.
Counting of past service.
Yes,
and
now I'll read.
regarding.
पत्र के सूचित किया जाता है कि श्री पी ताता राव, that is not printed properly, but you can read 22(1)(a)(2) bracket 3, right?
Yes, sir.
Now read. जिसका अंतर्गत से राव का मूल वेतन दिनांक 10/5/99 से 4030, it has been fixed, and that is a letter which is written by
Yes,
Survey General Office.
No, right. Does the officer continue 89? Right.
Thus, the officer served the parent department for a period of 5 months approximately. Therefore, he is not entitled to earn an increment on the post. Further, that is not eligible, I could not say, not entitled to keep lean in the parent post as he could serve the earlier department for a very short period. He understands of the opinion that the case of Tata Rao does not fit under FR 15A as he was not holding a lien on the post held earlier. Therefore, his pay cannot be protected under the said office.
1 minute, sir. If DOPT has already clarified in 2007, your Survey of India personnel writing these things, is he competent to do that? Right. That means DOPT has not clarified. That means up to 2009 also. Just read. The undersigned is of the opinion. Chadavandi.
The understanding of the opinion is the case of Tata Rao does not fall under FR 15A.
Oh.
As he was not holding a lien on the post held earlier, therefore his pay cannot be protected under the said rule as clarified in para 2 of Government of India, Department of Personnel and Training, established under 14/2006. This is
Correct.
2006 memorandum is not applicable.
అని మీరు ఒపీనియన్ ఇస్తున్నారు. Come back to page number 88.
Page number 88. I am directed.
This is 2007.
2007.
This is 2009.
89 2009.
Right? After 2 years. Right? So come back to 87, 88, 4/1/2007. Chadavandi అది.
4/1/2007, page 88. Directed to refer to a letter dated 28/9/2003 for the subject mentioned above. And to state that the matter was taken up by Department of Personnel Training for their advice approval. DOPT has fixed the pay of Tata Rao under FR 27 in terms of forum dated 17/6/1965. Subject to fulfillment of the conditions declared therein. You are therefore requested to refix the pay as per advice dated DOPT and send the copy of pay fixation along with the office, fixation to this office along.
That advice is not found, no. Advice 2007 లోనే ఉంటే 89 లో అది your Survey of India could not have written like this. No, I am of the opinion that 50. Who is he to give such an opinion? 2009 da. Kada?
Here in 2004, they fixed up under 22A1.
Huh?
Correct.
Thank you.
But if I have to look at it, 1765.
Standing counsel standing up and saying legally incorrect. Very good. We really appreciate.
2006, therefore, the wrong fixation went up and finally they said that you cannot fix it that way. You have to fix as per office memorandum dated 17/6/1965. Not a case of a transfer, though it might be a reputation, but it's not a case of a transfer. He attended 2 posts, one he stood successful, thereafter another post also, there was a result stating that he was successful. It was not a case of a transfer. The question of lien came into the picture because he served only for a period of 4 months. Therefore, he does not have any lien over the post for the contention before the tribunal. That's what we have said in the counter. Now, fixing of that, whether it can be done or not, the counter we have answered stating that it cannot be done. It has to be done under FR 27, which again falls back on 1965 one. It says that 1965 does not mean we do not have any right for pay fixation. Their contention was FR 22.
Come back to 70. It's a case of technical resignation.
Who is the appropriate authority actually to fix the pay? Is it DOPT? Then we don't have anything of DOPT. How can we also decide? That is also important, isn't it? Because if you see from page 85, every page you are changing your stand. 84, you say it is fixed as 22(1)(a)(2)(3), it is 4,000. In Hindi, it is just now read. Then subsequently, then you subsequent letters, you say 27 FR, then FR 15.
It was erroneously carried in the
4 times, sir. 4 letters. What is all this?
because such manner may have come and lost subject to manner. 17/6/1965, which is also Malacca, complied with Malacca petition. Case number 86 is the Malacca. IM 17/6/1965. All these terms are Malacca compared to Malacca in it, so that was clear. The conditions are stipulated Malad in OM 17/6/1965. So my friend is Malad strongly denying on the
Page?
page 86 Malad in Malad. OM 17/6/1965. Second paragraph. The question has now been raised as to whether the above benefit is serviceable to the government survey to go operate for post in the same after department before joining government survey. And on that account, the application was not able to be processed. The matter has been examined and it is now decided that the benefit of all survey is subject to the safe conditions which incorporated may be allowed in such cases also, subject to fulfillment of all
Clarification is civil 2006. Clarification is civil 2006 law. Like that, a big question. Probability has not applied for. DOPT is also under your control. Ask them to represent them, an officer of DOPT. Where is the clarification? Twinchen.
That can be recorded on the docket that I collect that docket sheet and I'll ask them to give an answer.
When the matter is taken up for hearing, standing on Deputy Solicitor General
brief the ASG about the case and the query which fell from the bench also.
Fifty-five Sheikh Gilani Basha, Chief of Services Store.
May I please lordships? Am I laudable, my lord? May I please lordships? My lord, this petition is filed questioning the judgment of the Honorable AP80 in OA number 12266 of 2009. My lord, the brief facts of the case are like this, my lord. I have been suspended from superintendent to my lord, lower cadre as senior assistant as I was working in the commercial tax department. My lord, the third respondent has issued proceedings on 5/11/2019, my lord, imposing a punishment, my lord, of reduction to the lower post of senior assistant permanently from superintendent. My lord, I have preferred an appeal before the second respondent. My lord, the second respondent passed an order rejecting the appeal with confirming the order of the third respondent on 17/12/1999. My lord, then, my lord, I have preferred a revision before the government on 27/1/2000. My lord, 26/12/2000, the government passed an order holding that as per CCA rules 91, there is no provision imposing a punishment of permanent revision to the lower cadre. Hence, the order of so-and-so is set aside and remanded the case to the commissioner for further processing and passing the orders. On 28/7/2001, my lord, the third respondent issued show cause notice based on the government order. Why major penalty should not be imposed upon the petitioner? I have submitted my explanation to the show cause notice denying the charges leveled against me. But the government kept the issue pending from 2001 to till the date of passing an order 6/11/2009. That is after 8 years, nearly 9 years, imposing a punishment upon me. But meanwhile, some of the juniors to me have been promoted, overlooking the claims. Agreed by said action of the the third respondent, my lord.
Where is that memo? 610.
Yes, page number 89, my lord. Lordship may kindly study. 98, sorry. 98, my lord.
Yes. Where under the original punishment of permanent reduction in rank, as was modified to the term, pay scale reduction of.
Page 98, my lord. My lord, para 5. Government, after careful examination of the matter, hereby decided to modify the punishment of reduction of lower post imposed against so-and-so to that of reduction of the reduce his pay by 5 stages in the pay scale in the grade of superintendent as the charges framed against him were held true. Questioning this memo, my lord, I have preferred a OA before the AP80. But the AP80 without considering the contents of the.
That you have retired, what remains, sir?
My lord, the reduction, my lord, 5 stages. Lordship are well aware, my lord, and considering the some consideration, my lord. No doubt, my lord, I have retired from services in 2017. But the reduction of 5 stages in pay scale, it is adversely affects my.
We'll remind the matter to you. We'll say. No, 1 minute, just listen. 5 stages reduction in Mandi. Make it some other punishment, stoppage of increment with something.
Only the category of superintendent. Earlier, its rank was superintendent. I give it to earlier, it was the punishment of permanent reduction from superintendent.
That is contrary to CCA rules, kada. Rule 9.
That is how not government itself remanded the matter. And ultimately now only 5 stages in cadre of superintendent, not even reversion rank. In fact, it's like without increments only. There are no stages in.
When did he retire?
No, when he was promoted, first of all.
Yes, yes.
When he was promoted as superintendent.
No,
5
he
stages
has-
ఉండాలి కదా నీకు అప్పుడే రిడక్షన్ అవుతుంది లేకుంటే
5 increments.
ఓకే అదే సార్ ఫస్ట్ he must be promoted as superintendent, he must earn 5 increments అప్పుడే రిడక్షన్ అవుతుంది కదా అది ఉందా లేదా చూద్దాం అది ఎగ్జామిన్ చేద్దాం. When you are promoted as superintendent,
My lord, those dates. My lord, this proceedings superintendent, yes, that I have to date. Because I'm sorry, my lord, because the earlier counsel on record is Mr. Anandrao, who is no more.
whatever it is, sir, when we are asking a question,
sorry,
please
I'm
answer
sorry,
directly, whether
I'm
you know it or don't say that. That's all. Amar, you should have 5 stages kada. The question of reduction appude vastadi. If there are no 5 stages, this punishment is unworkable kadandi. Kada?
By 93 he was the superintendent. By 93 he was superintendent.
Ekkadandi, from where do you get all those?
Page 6 of his affidavit.
Page number 80, my lord.
Page 6,
80.
chadavandi, sir.
Page 6.
Page number 80, my lord.
Was 3-1.
While working as superintendent of C-section Office of Commissioner,
Which paragraph?
1993. First para, my lord. 80.
One subparagraph 1 day. 3-1. After the paragraph, it starts one. Page 6. Writ affidavit.
అవునండి ఏముంది దాంట్లో?
The applicant while working as superintendent in C-section Commissioner of Commercial Tax during the period from 93 to 95. Punishment was imposed in year 99. Reduction of rank was imposed. He was having my lord. The reduction of rank was imposed on 5/11/99.
What is the allegation, sir?
Litigation brought in, he has committed certain irregularities while making appointment. There are several
Where is the charge memo?
charts before each at page 30.
$33.
Yes.
So he created a record that Srinivas is an employee of commercial tax department, right? Actually, he was not appointed at all. So by way of a transfer, he has been, yes, serious charge and if we cannot interpret it.
He does everything in one day.
All in one day. All occurred in one day.
So finally, you have removed that CS Srinivas or Ademandi Srinivas di? Suppose if Srinivas has approached the court and his appointment is regularized, then why penalize this person?
Lord, the issue before your lordships. Yeah, your lordships.
Karnataka వస్తాయి కర్ణాటకలో సోలాపూర్ సౌత్ సెంట్రల్ వాడి దాకా ఉన్నది ట్రాన్స్ఫర్ ఆర్డర్
as though their employees are to transfer on the which and then ఉద్యోగులకి ఇచ్చేసి అసంప్షన్ వాళ్ళపై లీవింగ్ ఆర్డర్ తీసుకొని లాస్ట్ పే సర్టిఫికేట్ తీసుకొని వాళ్ళు పనిచేస్తుంది కాబట్టి అంటే లాస్ట్ పే ట్రాన్ ఉండాలి ఒకటి సర్టిఫికేట్ అది ఎక్కడ ఉందా మీరంటే వాడు ఇస్తలేడు ఎక్కడ ఉంటుందా నీకు లాస్ట్ పే ట్రాన్ జీతం తీసుకోవాలి అట్లా బయటపడ్డాయి వీళ్ళు ఏం చేస్తారు దానికి పేరు పెట్టి వాళ్ళు ఇయర్ బై ట్రాన్స్ఫర్ వాడి టు చిన్న స్టేషన్ దగ్గర పంపించేస్తాం ఎక్కడ విజయవాడకు పంపిస్తారు అక్కడ చూస్తూ ఇదంతా ఏం చేస్తుంది అట్లయితే వస్తూ పని చేస్తాం
Punishment was already released.
Yes, you are right. It's a serious allegation, Andy. What's your name? Yes, Ilani Basha. By way of a transfer orders, you are creating jobs. Post after 2 weeks is not different.
They also it was paid in also certification.
But for us to dismiss his case, we must again inform him. No? We can't be opaque like you people. Government. We have to assign reasons. Post tomorrow, madam.
'56 T Mahendra Rao, Gadi Praveen Kumar.
Why, madam? Okay, post. When do you want? Tomorrow.
57 PB Vijay Kumar, Gadi Praveen Kumar.
Yes. 2 weeks, right?
58 PV Ramana, GP for Services 1.
Case of contention of I raised the ground before that. Repair officer, there are 3 charges paid against you. Repair officer gives finding except first charge, 2 and 3 are then after submitting report.
College notification.
The report was submitted to me. The show cause notice was issued.
Yes.
After I submitted the objections to the report, the matter referred to the government. The government referred the matter to vigilance. Vigilance referred the government directly to the government to defer with the charge 3. The charge of accept charge 1, charge 2 and 3 are not proved. And the government referred the matter to vigilance. Vigilance directed the government to defer with charge 3. In fact, to defer with charge 3, there is no evidence at all in the report prepared by the tribunal for disclosure trustee. Then when I, in spite of raising objections, a punishment was imposed, permanently cutting to 25% of the pension. Finished that order, I filed review before the government raising all these points. Government also not considered my review any of the accounts, including vigilance directions. Versus 1 second, I will bring the versus notice.
Where is the TDP report?
TDP report it starts at 39. There's 41 3 charges they are extracted.
Page number.
Page it starts at page 39 report starts. Page 41 3 charges they have extracted. Charge 2, 3 minutes as per the report of TDP not proved.
Where are the conclusions, sir? Where are the conclusions?
Conclusions in respect of this. Page 44 and page 46 in respect of conclusions of charge 2 and 3.
Oh, read back page 44, sir.
44, yes. Page 46, para 8 minutes, finding your.
No, come back to page 44 in respect of first charge.
Page 46, para 8 is finding you have made a error.
Oh.
Right, page 46.
Yes. Second charge is not true.
It's not true, government agreed with this.
Oh.
Page.
What about charge 1?
Charge 1 proved.
Oh.
Charge 3 Millard, as per report Millard is not proved. Charge 3 at page 46.
Oh.
Charge 3 I have extracted.
Where are the conclusions? Where are the conclusions?
Yes. Collaborative discussion is 47, 48, 49.
Oh.
Page 49, bottom Millard analysis. So places after 3 pages discussion.
The charge 3 is also not proved. What is proved then?
Charge 1, as per the report of tribunal for discipline, is proved.
Oh,
Now charge 3 is deferred by the government.
correct.
Based upon the vigilance.
Hmm.
To say it is deferred, there is no evidence at all for quoting evidence.
Where is the dissent note?
The para, Tota's notice at page 60 also, so please 60. Para 3 will also sees the dissent.
So, charge 1 is you are signing the attendance register though you are absent. That's the allegation. That is held to be proved.
That is proved.
Where is the dissent note?
That is page 1, page 60.
Hmm. Hmm.
I have examined the report of criminal process. The report reveals that charge 1 framed against Jatindra Reddy is held true, and charge 2, charge 3 are held not true. It is observed that with regard to charge 3, that the charged officer apparently collected money, though now he is saying it was for dissertation work, which is not acceptable as there is no zero. As such, he collected money for dissertation work. Hence, the government disagree with the findings of criminal service of the degree, while agreeing with the
So
findings.
your case was you have collected that money for dissertation work.
No, Millard, that is not my case at all.
But that's what is.
Millard, it is given impression that I have accepted money, this allegation for money for accepting dissertation work.
Come back to page number
The charge is Millard,
59.
1 second. Charge itself is 41. Third charge will also show. I never accepted this allegation.
Charge 1. Oh.
Third charge will also show, please. That you, Jatindra Reddy, while working as professor, head of the department, actuated by corrupt motive in a abuse of your official position, collected money for postgraduate students for accepting the dissertation and passing them in examination, and thereby you are guilty. Charge is that I collected money for postgraduate students for accepting dissertation.
How the TDP dealt with that? Let us see.
That is at page 46 onwards.
Right, read.
46 onwards. 3 paragraphs. 3 pages.
So 48, 49, 50 దాకా ఉంది. మళ్ళీ charge 1 కి వెళ్ళాలి 50 లో again why charge 1 is referred again at page number 50. TDP has answered that.
First charge they have considered in the last. Second and third charges they have discussed elaborately. First charges they considered at the last.
No, page 44 is dealing with first charge only. Para 6. 44 para 6. there are 3 charges framed against charge officer. Charge 1 relates to absence of so and so, and later on signed in the so and so as he has attended it on the said day.
The 2 are para 7 onwards, they have considered charges independently. Charge 2 plus charge 3 next. Charge 1 as the last one they have considered. Independent findings in respect of each.
Okay, 46.
As regards charge 3, CO was charged with the collection of money from PG students for approval of their registration and for passing them in the exam. For proving the charge, the prosecution examined 3 witnesses and marked the statement of some of the staff members as TDs. PW1 is complaint to work as Commissioner of Pajavadana Purchase Hyderabad from 2000 to 2006. And during his tenure of office, he report against CO to the government recommending the suspension and initiation of action against him for the misconduct alleged against him. He preferred his complaint only on the basis of telephonic message received by Prasad, news reporter of Enadu newspaper and newspaper clipping that was published on 6/7/2002. Also, a preliminary inquiry was conducted by him in Usmania General Hospital by inquiring the doctor who are working in a STD department against the activities of Steve. Basing on his information, we asked for initiation of action. Evidence 1 of PW1 bears some importance, but other 2 witnesses who are working in a STD unit of Usmania General Hospital, Hyderabad, bear great impact. They have association with the CEO for considerable time. PWT is D. Gopalakrishna. He was an assistant professor of the studying grade. Dr. Mohan Rao, PG student, he also started working in the unit. Therefore, their acquaintance with CEO and their knowledge about activities of CEO have great bearing on this aspect. PWT could not say that he got personal of money from PG students to pass them in the examination and to approve their presentation work subject to exam. But he came to know only from PG students. He did not also say the names of PG students who gave information and who gave money to charge officer. They are passing the examination and for approval of their presentation work by their formula. Procedure of passing of PG students in examination as per PW2 and TW2 is as follows. There would be 4 examiners consisting of 2 internal examiners and 2 external examiners, and all of them shall be studied at once. This particular case, 2 internal examiners are CEO and Sudarshan Reddy. Sudarshan Reddy is another report. External examiners will be different. All the 4 examiners should collectively approve the presentation. They should recommend the PG students for passing in the examination. Therefore, one of the examiners may not be able to pass any PG students or approve his presentation work single-handed without help of the other examiner. If one examiner accepts any such bribe or money for passing PG student, he should share the money with all examiners to do such thing. Therefore, the allegation of CEO collected money for passing PG student in examination and for approving the dissertation work for the PG students finds no strength. In view of the evidence adduced by the prosecution, the evidence adduced by the prosecution is insufficient to say that CEO collected money for the work. When prosecution witness 3 gave evidence before the victim, he stated CEO collected money from him for meeting expenses of examination. He did not whisper anything about passing of examination and approving presentation. If really money was collected by CEO for that purpose, then the purpose for which it is stated in the allegation of charge should be thrown out of.
1 minute, Ramna. No need of reading so much. Show us the material for disagreeing. At page number 60, we have issued this dissent note, para 3. It is observed that with regard to charge number 3, para 3 I am reading in between, okay, that the charge officer apparently collected money. No, now he is saying that he never admitted that this disagreement note itself is. Now he is saying that it is for desertion work, which is not acceptable as there is no GO for such he collected money for this dissertation work. Hence the government, where is this finding, where is the material to say that he has collected money for అది ఒక్కటి చూపిస్తే సరిపోయింది ఫ్రమ్ ది ఎవిడెన్స్.
Yes, but presently we are not having that.
That only goes to the point.
Yes. But an aspect of that is what it went to vigilance according to my letter.
Oh.
The matter was after the inquiry.
No, he must be given an opportunity. Vigilance findings are like this.
May I suggest one thing? Already charge 1 is proved. Regarding charge 3 TDP and it is not proved. But a dissent note was given. Your lordship may remit the matter to that from the where they have not considered this case. Let them take the material into consideration and pass appropriate orders. If one particular charge is proved already, a 25% cut in pension is imposed, and if third charge
No,
brought
what I mean to say is, for how many days he was fined like that is a point which has to be looked into. Only first charge, based upon, no, 1 minute, based upon TTD's report, you pass in yours.
Yes.
Whatever punishment you want to impose, you impose. But don't go by the dissent note, because there is no material, at least.
Since there was a point out brought to the government that from vigilance angle was there.
అవునండి, ఈ ఎంక్వైరీ ఆఫీసర్స్ రిపోర్ట్ ని ఎలా డిసగ్రీ అవుతారు? బేస్డ్ అపాన్ విజిలెన్స్ రిపోర్ట్. విజిలెన్స్ రిపోర్ట్ వాజ్ నెవర్ సబ్జెక్ట్ మ్యాటర్ బిఫోర్ టీడీపీ కదా అది.
Government can disagree under 21(3).
No sir, disagree with the findings of enquiry officer pertaining to the very same enquiry, because some other material of vigilance which was not available before TDP. How could TDP visualize that vigilance?
May I suggest one thing? Let the government may independently take the whole situation into consideration. Let them pass appropriate order.
అది కరెక్ట్ మీరు చెప్పింది, కానీ విజిలెన్స్ హౌ కెన్ టీడీపీ విజువలైజ్ దట్ మెటీరియల్ ఈస్ హ్యావింగ్ విత్ యూ?
Whenever brought there's a
No sir, before TDP we have present three charges and 3 witnesses, PW1, PW2 and PW3. If you have something additional material in the form of vigilance, that also should be subjected before the TDP, and you must have lead evidence through vigilance saying that these are the additional charge you can frame. 4th charge you can frame during the reference, during the pendency of matter before the TDP. It has also come to our notice that vigilance angle also is there. This is a material and చూపించాలి కదండి.
in on charge would be the same.
No sir, material will not be there. No vigilance.
That's where we not be lacking the information regarding the availability of the material. My friend argued on the point that after the disagreement there was no basis for them to.
No, he must be given an opportunity of vigilance.
Requesting your lordship that consider that point, Lord. Let if he given an opportunity from that point and take Lord the whole situation into consideration.
Though we'll set aside the punishment order and also dissent note. Let the government consider and pass appropriate orders. Because dissent note, whatever, we are not saying anything. You are entitled to impose any.
Concerned, they are entitled to consider that independently, they can pass any.
Let them pass any take the whole situation into consideration and also give him.
Charge 3 is concerned, there is no evidence at all to say that I accepted money.
That is what let them examine.
అది కాదండి, విజిలెన్స్ ఎలా వేర్ ఇట్ ఈస్ ప్రూవ్డ్ అనేది.
If your lordship wants not, I'll also ask the department to give that particular information in 1 or 2 weeks.
No, pass over.
That old record brought this is 2000.
అది కాదండి, జస్ట్ మీరు గవర్నమెంట్కి వెళ్ళి ఇది తీసుకోనండి. మీరు ఏది డిసెంట్ నోట్ ఒకటి చదివి వినిపియండి. పేజ్ నెంబర్ 16
16.
పేజ్ నెంబర్ 16.
Because notice itself they have stated, page 60.
1 minute sir, విజిలెన్స్ యాంగిల్ ఎక్కడ వచ్చిందండి?
My friend argued not by
No, not in this manner. After submitting my objections to the report, they referred the matter to vigilance. Vigilance asked them to defer for charge 3. Accordingly, they have deferred and issued this punishment. I have raised this point in my.
Where is that vigilance?
Vigilance, my dear Lord, that's all. In my revision review, I stated all this.
Where is it? What before us?
Page 68. Page 73, second para, you'll have to show this. Page 73, second para.
But you have given a reply to the show cause notice dated March 2007. In that, did you raise that point?
At that time, I am not aware, page 73, you'll have to show this.
This is what, sir? This is what?
73.
These proceedings of what?
I filed review when after they imposed this punishment, I filed the review. I have given all the
The other one.
page 73. Further, the vigilance of EP Hyderabad, though their first letter referred in 26 reference cited, advising the principal secretary to reduce pay of three stages in the existence.
Where is 31/1/2007? ఎక్కడ ఉంది అది? అదే మీరు చదివింది 23rd రెఫరెన్స్ అదే డేట్ అది 31/1/2007 విజిలెన్స్ డిఫర్ చేయమని అన్నది ఇక్కడ ఉంది ఆ లెటర్ ఎక్కడ ఉంది మీరు రాస్తున్నారు ఆ ప్రొసీడింగ్స్ ఎక్కడ ఉన్నాయి 31/1/2007 then
All dates, sir, I have addressed to the government, but review the entire case. They rejected my case once again.
And page 63 is incomplete and
63.
63 చూడండి ఒకసారి. We did not find page number 2.
63, and there is a continuation at page 58. Page 58 is the continuation.
ఓకే దాంతో ఏం సంబంధం లేదు రైట్ లెట్ us go to nothing to do మీరు yes what do you say
Losses. On that point, Lord, it can be remanded back to the authority. I'm not considering the facts that placing on record that fact one is proved.
okay we'll continue at lunch come let's get this
But on the lunch time, past.
we'll dispose of your colleague will be there without going into the dissent note pass orders there is a
They have power.
correct sir dissent note they have power but the dissent note the way it has been issued in para 3 what it says that total incorrect finding is recorded as though he has admitted that he has collected the amount for dissertation which he has not done that Adi. That's the point
If note lot is not given with reasons and material, from that stage, right, can be rectified.
okay you are entitled if you want to disagree and with proper
Yes.
as per law
Yes, but his material is also.
Sir, in 2007, I retired. Without there being any evidence, they want to differ on what basis they differ, they should place it with.
that's what they'll do it
Again, they cannot be.
1 minute.
Never can the issue.
no 1 minute if there is material for them to disagree let them disagree
Let them is now place it before losses. Absolutely.
then
there
get
is nothing
instructions
in the
post after 2 weeks what is the material for disagreeing sure
report says nothing, they cannot.
2 weeks
So similarly, here and there.
230 candidates.
Leadership only. Send question. 27 లో అనుకుంటే చూసుకుని వస్తాను లేదు
20.
అప్రాక్స్ మీటింగ్ అయ్యారు సార్ ఆయాను
బాక్స్ తీసుకున్నాను బ్రో
అది తీసి పెడితే ఎన్నిసార్లు గుచ్చి పెడితే ఆ కింద పీక్ పెడితే అప్పుడు వచ్చింది ఆ లైన్ ఇన్ అని.
ఓకే, ఇప్పుడు మొబైల్ జాయిన్ అవ్వ.
జాయిన్ అవ్వడానికి అది ఏదో చెప్తుంది. ఏమో అర్థమే. ఏంటి జాయిన్ మీటింగ్.
సో దీని నుంచి సౌండ్ రావట్లేదు అంటే
అంతే. ఇప్పుడు దాకా బాగానే ఉండే.
జాయిన్
అందులో నుంచి జాయిన్ చేసావా?
ఎవరైనా
సైకిల్ చేసుకున్నాం ఫస్ట్. మేడం వచ్చారు. ఆ మేడం పేరు ఎప్పుడు తీసుకోవట్లేదు. మేడం పొద్దున్న ఒక ఆవిడ చెప్పారు మేడం.
జాయిన్ చెప్పు.
ఒక ఆమె అడ్వకేట్ మేడం. అవునండి.
అయిపోయింది ఎంతసేపు జస్ట్ చెక్ చేసుకుంటే
చేసినాను. కెనాట్ జాయిన్ దిస్ మీటింగ్ ఫర్
డౌన్లోడ్ చేసుకున్నా లేదా గూగుల్ నుంచి
చేసిన ఉంది, యాపే ఉంది. అట్లా మళ్ళీ వెనక్కి వస్తుంది.
మీటింగ్
చూడు ఇప్పుడు అసలు ఏం డైలాగ్ మళ్ళీ రిపీటెడ్లీ కొడుతుంది. దాని నుంచి కొట్టి చిరాకు.
सबीर बोलो बोलो सबीर 27 गया सबीर 27 गया आ जाता एक 10 मिनट అది ఏమైనా అప్డేట్ అడుగుతుందంటే
సరే పెద్దలే అయిపోయింది కదా.
నా మొబైల్ ఉండు బ్రో
ఉంటే పంపించు. నీ మొబైల్ ఉంటే చేయొచ్చు.
టెస్ట్ చేయకుండా
ఇక్కడ ఇప్పుడు వచ్చినది ఇది పెట్టుకున్నా. స్టేటస్ ఉంది.
ఒక నిమిషం ఉండు. ఇంకా నీకు 45 minutes ఉంది కనీసం. వచ్చింది కదా సంథింగ్. ఈ వాయిస్ వస్తుందా దానిలో ఏం తెలియదు.
కాకపోతే ఇక్కడ హెచ్పి ఉండేది కదా, అది లేదు ఏంటి అని ఆలోచిస్తున్నాను.
అవును హెచ్పి అనేది ఉండాలి.
ఎన్విడిఏ గ్రాఫిక్స్ అని ఉంటుంది కదా, అది ఎందుకు రావట్లేదు? యూఎస్బి ఎందుకు వస్తుంది నా క్వశ్చన్.
సో యూఎస్బి కనెక్ట్ చేయలేదు మనం ఆడియోది, జస్ట్ లైన్ ఇన్ పెట్టాము. సో ఇది రావాల చాట్ బాక్స్ ఆప్షన్ వస్తుంది. వస్తుందా?
యూఎస్బి అని వస్తుంది.
ఇదే కదా మనకి యూఎస్బి.
హెచ్పి అని వచ్చి
కనీసం నేను జాయిన్ అవుతాను అనమాట.
బెస్ట్ ఆప్షన్
కనీసం 6677077 499.
ఒక్క నిమిషం చూస్తాను పాస్వర్డ్
అవైలబుల్ లేదంటే
తర్వాత నేను పిలుస్తాను ఇది అయిపోయినాక నేను మాట్లాడినా కలిసి ఢిల్లీ కూడా ఉన్నది ఢిల్లీ ఉన్నది ఎలా చేసి పారేస్తాను డిమాండ్ చేయమని క్యాన్సిల్ చేస్తాను ఎప్పుడో చూసాను కానీ నాకు ఇది రాలేదు దృష్టి నాకు కూడా పిల్లలు అడ్వకేషన్ పిల్లలు వాళ్ళు రాలే నేను కూడా ఒకటి వారు ఎత్తాడు పేపర్ చేయలేదు సార్ మీరు నాకు సెట్ అయ్యలేదు చైర్మన్ మీరు నేను సర్వే నేను సర్వే గారు తీసుకున్నాను కరెక్ట్ తీసుకోండి సెక్రటరీ అండ్ చైర్మన్ వైస్ చైర్మన్ రోల్ సెటిల్ లేదు సెక్షన్ మనకి
Selected in Survey of India in a lower post. So, whatever it is. So from the stenographer on this thing, he opted technical resignation, came and so Government of India has issued a clarification memo 14/2/2006 saying that whoever is transferred or allowed to come on technical resignation, that pay in the higher post will be protected. Whatever it is. Whatever it is. Correct. Correct. Pay fixation. Suppose one extra pay will be given treated as a personal pay to him. Difference amount. So that will be continued for rest of his service. In fact, Survey of India has given that benefit to him in terms of 14/2/2006. Then audit has raised an objection.
I've seen that.
So when audit has raised an objection, the matter was referred to DOPT.
Yes.
DOPT, that clarification by DOPT is nowhere.
It is exactly, but that is the truth. I have seen.
Correct.
Brief discussion.
So they are referring to counters, some proceedings and all those things.
That proceedings is missing.
That proceedings is missing. And Survey of India says, in my opinion, when you have referred to DOPT, where is the question of it is total non-application of mine. Opinion, correct? Is a professional to give opinion? Thank you very much. Correct. Only a professional can give an opinion, according to me. Am I right? And again, that opinion is subject to whatever law says. Whatever it is. Subject to. So generally, advocates give opinion based upon certain documents. Certain documents they will not refer.
Document itself is missing.
Will not be referred.
Only thing subject to that. Same that I had a discussion also with the officers. As your docs put it, the DOPT advice.
And mind you, that 50 rupees, that man must have retired. 50 rupees all put together, litigation must be worth. Okay.
He's very much in service. He has long service also. No difficulty. Now 50 rupees. What these people did is, I have seen.
It is 50 rupees only, sir. Please. We have seen that. 50 rupees only. Page number 68.
What I am saying.
Please see 68, sir. Read last paragraph. 50 rupees is treated as personal pay. Read.
Yes, yes.
Thank you very much. Understood.
Same
Right.
page only.
Right.
That is the reason for this advice of the DOPT 28/9/2006. This is the thing from nodal authority.
No doubt your colleague Anurag did a wonderful job, but because of
The opportunity also given that. What I respectfully submit, kindly accommodate a week time.
no, because we wanted to summon DOPT officials because this is going on since 6 months, mind you.
Put that period, I
So we didn't want youngsters' name to be recorded while summoning somebody.
But
So
not that purpose. But to say answer that, this 28/9/2006, this DOPT advice, let me get the copy record so that that can be placed before your heart. That clinches the entire issue.
Thank you very much.
Opinion and other things is no use. Survey general officers who were employees.
And we were also informed by the bar, whatever we are discussing, it is being, am I right? That is a
digitization.
So that is a very dangerous thing. Sometimes we may discuss something. No, that is right. When we are discussing,
Exchange of thoughts between your lords.
should not be allowed to go on air, no? That's a very dangerous trend.
Yes. Sometimes not, it is very painful to.
How to regulate, we are not able to understand.
The thing is, your lords has to switch off that, when your lords exchanges with the.
Why they-
Sometimes. Of course, it is.
How to switch off also we have to learn, I think.
Also we have.
How to switch off, we must also learn that, I think. Maybe switches are all on the other side. executed a gift deed.
Goes for hearing, the first appeal itself, right? No, 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 cannot be, cannot be. Cannot.
Otherwise, what happens? Tomorrow, not the
Do we have to pass a speaking order rejecting his yes or that's what?
At least,
No.
whatever is there in the, let them not change the nature of the associated property.
Sir, 1 minute, sir. Your defense is the person who has executed a gift deed was doubting the gift on the ground that he has already entered into an agreement of sale in respect of somebody. That agreement of sale is dated 25/6/2012. That has been created just 2 months prior to this gift deed. Whether, just tell us whether 24/8/2012 is a registered gift deed or then
If there is an agreement of sale in favor of the daughter-in-law, why should gift deed be executed in favor of the senior veteran? Most improbable.
maybe. Sir, it's a registered document. 1 minute, one cannot be doubted. One cannot. Correct. Gift is like this, sir. The concept of gift is once the donee accepts that it has become final. It cannot be revoked. It cannot be revoked.
That is not the law. Here, fraud means not everything is kept out.
Fraud on the no fraud on the document. You are right, but on the ground that you have already executed an agreement of sale, it may not be available.
General power of attorney in favor of the mother-in-law, the senior maternal-law. That's how we not the entire case is set up. He is an illiterate. Kindly consider this. And one important aspect in the matter, 5,50,000 is the stamp duty. He never paid. The case is that that lady who has virtually no financial status, paid that amount. No, she never paid that amount. It's all concocted case. Very simple case. Kindly see this evidence of DW. We'll not two at one. DW2 is the son. Just see that the evidence of DW2. It's impossible not to believe. 118 at page 118.
I'm cultivating what you said.
Then let it not. No, so then we'll not hear what it is. That has no objection.
No, I'm cultivating land. I just have a friend, it's a we could take care of it. But still, you're not going to say any alienation. Subject to
That's all right. Whether I'm referring to the other aspect. Or let's say if he is cultivating, let it not be changed. I think we got to.
again, subsidy, I'm 10 years. Still, I'm again.
No, I'm saying let him cultivate. Not 1 minute. Let him cultivate the matter, the land. Let him be in possession also, if at all. If he is in possession, the only thing is let him not convert this land from agriculture to non, which is already there. If he is cultivating, what is the problem? Yes. Then that may be recorded. That may be recorded.
5 years or 10 years down the line, if you want to convert it also, I can't prevent it by appeal. It will take 10 years, 15 years, 20 years, I don't know. I will subsidy for after 10 years. Soon is of the year 2012. You are not with anything in subject of the appeal.
Not that way, minute. Anyhow, we are not. Yes, obliged.
Yes. Lots of do that external.
Yes, yes. Yeah.
Otherwise, we will hear and record. Somebody will record, not us.
No problem, sir. We are not afraid of anything. That is for sure. As long as we do everything as per our conscience, we should not get afraid of anything.
What to do, senior counsel? What to do, I said, senior counsel.
Let us, it's okay, let. Yes.
So we are for things that are the question going to something doesn't. And what should be coupled with some criminal case to realize out. Civil case of various. Was there any criminal case? Fraud.
Not between us, no criminal case. Between my esteemed daughter-in-law and my, no case, criminal case filed against the mother-in-law.
Alleging fraud and all this.
No criminal case.
Fraud also is a concept of criminal, this thing also.
No criminal, one of the finding given by the trial court.
Correct.
No case.
Because if the allegations leveled are, it all fits into section 420, cheating. So inducing somebody to part with the property, no? Cheating should have been filed, yes. Cheat. Your case, you should have taken criminal action also if you are alleging, because it amounts to cheating, inducing.
He is the son of the senior.
Hey, not on that. Beneficiary of this document, gift deed is. No. Beneficiary of gift deed is respondent number 1. All right.
Yes.
Then you should have filed a criminal case against her. Why? No.
Consider this. It is behind all the son of that Dhoni, behind all this litigation. Criminal cases are filed against him. There are several cases he has.
Criminal cases are there. Criminal cases are there.
Yes, there are criminal cases against him.
Not in this regard. Not in respect of executable.
In respect of the very same family only, there are criminal cases filed and they are all.
Okay, we'll see. Next Tuesday.
What are the criminal cases that are filed and what is the conduct of these two? And one important circumstance here, 5,50,000.
అవి 3 applications, condone delay, contempt వాళ్ళు చేయము.
Paid by deed. It's stated on this, because the entity is not capable of.
వాళ్ళకు ఒక రోజు ఆగస్ట్ అయిపోయింది.
This is the gift deed. The always stamp duty is paid only by the donor.
నెక్స్ట్ వీక్ ఏమన్నాము, నెక్స్ట్ వీక్ చేయండి.
What shows that the donor has paid 5 lakhs and not. It's impossible to believe this case.
Next.
So you also may kindly consider.
We'll see Tuesday.
Next Tuesday.
Tuesday.
That circumstance is.
Next Tuesday is 14.
Not the. Trial court.
No, not tomorrow. 14.
Next Tuesday.
Next Tuesday.
13 and 14 you have actually the fraud in agenda will be.
May I please? My Lord, there are 3 applications, my Lord, with reference to death of the sole defendant. Application, my Lord, is to condone delay in filing an application to set aside the abatement.
Yes. Yes.
Mr. Anthony Reddy, Lordship, he has said that he has no objection as allowing the LR petition.
Those are 3 LR petitions, my Lord, LR petitions. There is 3 applications, IA number 1, 2 and 3 relate to or with reference to death of the sole defendant.
1 minute. You are representing whom, sir?
I am representing the Lord appellant.
You are representing Rajendra Reddy.
I am representing Mr. Ramchandra Gaud.
Ramchandra. That is a contempt he has filed.
I'll come to the contents slightly later. Will your lordships kindly?
So you are asking us to look into item number 14.
Item number 14 is appeal. 14 is the appeal.
Cross objection is there. You have filed.
Yes. There is a cross objection also.
So there is also automatic admission, I think.
Yes, my lord.
All right. Next.
But what kindly before.
No, 1 minute. Next is IA 1 of 2021.
2021.
What is a condone delay?
Condone delay in setting aside the abatement.
What is a madam? Can be ordered. Correct. IA 1 of 2021 for the reason stated therein it is ordered. Right. Next term
is to set aside the abatement.
IA 2 of 2021 to set aside the abatement ordered amma. IA number 3
is to implement the LRs.
LRs adi kuda ordered amma. IA number 3 of 2021. Next permission petition 1 of 2022 also ordered.
That may be ordered. But shall I?
Petition can be ordered.
What happened, my lord, is
appellant is represented by a managing partner, sole managing partner. He died.
Hmm.
His son, filed an application saying that the partnership firm be allowed to be represented by the son. That's all.
It's a permission petition.
Permission petition.
No, for that, once person dies, partnership gets dissolved, no?
No, partnership it's a proprietary partnership.
Edaina.
It did not get dissolved.
What is? That's too fundamental. Don't say all those things.
It shall have to be, it's a proprietary concern, my lord.
But partnership అన్నారు కదా మీరు.
There can be a proprietary firm and my lord, there can be firm by partners.
No, cannot be. What is?
It's a proprietary firm. All right, I stand corrected. It is a proprietary firm.
Right. Thank you very much. All right.
It's a proprietary firm.
Correct.
If the proprietor dies, not his LR, who is the son.
Has come already on record.
Yeah, he wants to come on record representing the firm.
ఇంకా పర్మిషన్ ఎందుకు అది అక్కర్లేదు ఇంకా ఎల్ఆర్ ఆర్డర్ అయినాక కరెక్ట్
I thought it's necessary.
No, you are fundamentally incorrect. Correct.
చూసాను బా
Right.
representing.
Permission petition rejected. Right. Right.
Firm has to be represented by someone, my lord. My lord.
No, 1 minute. Come back to page number 17A. Look at the cost item.
Cost title, my lord, AS 327, your lordships are looking into.
Yes, 12 lakh. It's a
Three
partnership.
Ganesh Enterprises.
No, it's a partnership firm under me.
It's a firm.
No, partnership firm under. 44 చూడండి page number.
In the appeal or contempt, my lord, your lordships are.
Page number 17. A.
17A. Right.
మేనేజింగ్ పార్ట్నర్ అనే పదం యూజ్ చేశారు. పార్ట్నర్షిప్ లేకుంటే మేనేజింగ్ పార్ట్నర్ ఎలా వస్తారు?
17A, Sri Ganesh Enterprises, previously known as Gopi Stone Crushers and Company.
రిప్రజెంటెడ్ బై ఇట్స్ మేనేజింగ్
Managing
పార్ట్నర్.
partner C.S. Satyanarayana.
మరి పార్ట్నర్షిప్ కదండి.
It's described as a partnership firm.
మరి
All right, I'll come back, my lord, your lordships may. I'll just file the.
అందుకోసం ఎల్ఆర్ కూడా అన్ని తీసేయండి అమ్మా ఆర్డర్స్. అలా నిన్నాక పాస్ చేద్దాం. పార్ట్నర్షిప్ ఫర్మ్ లో ఒకటి చనిపోతే డిజాల్వ్ అయిపోతుంది.
I'll produce the my lord, the partnership deed. I'll produce the partnership deed.
అన్ని ఐఎస్ తీసేయండి ఆర్డర్ లేదు. పోస్ట్ ఆఫ్టర్ 2 weeks రైట్. అలా కదమ్మా. లెట్ దెమ్ ఫైల్ పార్ట్నర్షిప్ డీడ్ ఆర్ కంపెనీ.
Right.
On the in the event of one person dying, what is the effect of maintainability of a suit? Whether LR can come or not, అది చూడాలి కదా.
Sale.
అది ఇంకొకటి పార్ట్నర్షిప్ ఒక మనిషి చనిపోతే మళ్ళీ రీకాన్స్టిట్యూట్ చేసి ఒక రెజల్యూషన్ పాస్ చేసి the pending suit which was filed by the partnership firm be permitted to pursue అన్నట్టు దాన్ని ఉండాలి.
If there are more than one partner, my lord.
పార్ట్నర్షిప్ అంటేనే ఒక ఫండమెంటల్ ఏమంటే ఒక చనిపోతే డిజాల్వ్ అయిపోతుంది.
It goes by firm theory.
సీనియర్ కౌన్సిల్ మీరు ఎట్లా మాట్లాడరు. ఇవన్నీ కాలేజీలో చదువుకున్నాయి సింపుల్ థింగ్స్ కదా. By 2 weeks. Let or after elections if you want.
So if possible, I.
Correct. Right.
I will be.
You are the person who were arguing through online in the morning.
Yes, my lord.
చెప్పండి. Your case is liable to be allowed, I think. Writ petition is filed.
Writ petition is filed, agreed with orders passed by the Central Administrative Tribunal, invoice number 174, 2009, dated 4/11/2011. Heard, Shravan Kumar,
Yes, ma'am.
counsel for the petitioner.
Mayor
And-
Shravan Kumar. Mayor Shravan Kumar.
అదంతా అక్కర్లేదండి, శ్రవణ్ కుమార్, right. And Deputy Solicitor General of India for the response. It has been contended with the petitioner that he is a member belong to Vanjari caste community. And the state government had issued UMS number 245 dated 36/1977 or caste? అట్లా పవర్ ఉందా మీకు? అదే ఎట్లా మీరు ఎట్లా చేంజ్ చేస్తున్నారు అనేది మీరు ఏమైనా చేసేయచ్చు కదా. The council for the response had contended that the petitioner does not belong to scheduled tribe community. When the state government itself has withdrawn the Vanjari community from the scheduled tribe community by GMS number 44 dated 23/2/1979, the question of treating the petitioner as a member belonging to scheduled tribe would not arise. Therefore, the disciplinary authority, after conducting yes, sir. The response are directed to release all the benefits, including arrears of salary, if any, to the petitioner, right? Next. You must know where to stop, correct? Thank you. No, no, no. No. That's a good ground for you to go to Supreme Court, no? Challenge your order. In the interest of justice, at least I prefer, I don't mind if my order is also reversed in the interest of justice. Correct. What is this Vanjari community person? What is you? And how can appellate authority enhance the punishment from compulsory retirement to removal? Next. It is needless to say, the orders passed by the Central Administrative Tribunal are liable to be set aside and accordingly they are set aside. Writ petition is allowed, right? Next.
First, I can show lordship direct me to get instruction whether unofficial respondent can provide alternative arrangement to lordship.
No one చెప్తారు ఇంకేముంటాయి కదా. It is not feasible, huh? What is the post? How many years of service you have rendered?
10 years. 10 years. 2009 is
So after filing of writ petition, any orders to continue you?
Stay.
So by virtue of stay orders, you are continuing. You could not secure employment because of pendency of this report.
He got some other employment, that is very category, he got employment, he is working.
Is it so?
That is for the beat office.
Beat officer.
Get revised instructions. Settle just one.
They can ask for PH.
No. You are already working,
SBO, loyal force.
whatever it is. NES service sir. Promotion ki consider cheyamandam higher post. Adi a direction istam. And a case promotion ki consider cheyandi అయిపోతుంది.
I will get in.
Again, there is a
Seniority.
అట్లాంటి అన్ఎండింగ్ సర్వీస్ మ్యాటర్ అంటే చనిపోయినాక కూడా ఇడోరు ఎల్లార్స్ వస్తారు వాళ్ళు వస్తారు కదా. లెట్ us be reasonable, Ravichandra.
I'm very reasonable, but I was finding.
No, we'll direct you to them to consider your case for promotion. Okay. When you were appointed?
2009, 2009 I was.
2009.
But in all divisions, similar procedure has been followed, Your Lordship. All divisions. Selection took place in different divisions, Your Lordship.
How to resolve, you better think now. Right or wrong, that person is working for more than 1.5 decades. No?
Now, moreover, FSO post has been considered only for promotion, Your Lordship. By recent amendment to the rules, Your Lordship. That was the instructions, Your Lordship. Your Lordship, page 2, last but one paragraph, Your Lordship.
మీరు కన్సిడర్ చేస్తుంటే రిటర్న్ ఇన్స్ట్రక్షన్స్ తీసుకోండి ఆయన కేసు ప్రమోషన్ కి కన్సిడర్ చేస్తుంటే విల్ కెన్ క్లోజ్ ద కేస్
Next week, Your Lordship. Next week.
దట్ వుడ్ బి బెటర్. Let the Ravichandran's client also be considered for promotion if he is eligible. In order to resolve, adi me undertaking mida we can pass an order. No, you are appointed when, sir? Forest beat officer. We are concerned with forest section officers. Forest beat officer is a feeder category. Okay. When you are appointed? 2009 and 1912, correct? When you are appointed as forest beat officer? Yes. Huh? Somebody else brief ante మీరు చదవరా?
They are not mentioned that date as a due. The entire issue what is latest.
But get instructions when you are appointed. Okay. Next Tuesday. Please get the result. Your appointment process. No, he says I'm more meritorious than him.
Is a different issue.
Huh?
That is a different issue. Okay, he should be given that in time. He was not very with the promotions. Yeah, so the industry which is crossed to. Growth. I don't know. But one just the others are continuing to build. And then state of industry of positive. They wanted this program.
What is the marks you got? 44.
44.7. I have been answered soon.
44 point?
43.78, Your Lordship.
775.
43.775.
Actually, 103 marks more. 85% is 43.77.
You are supporting whom, sir?
Repetition.
Huh?
OA, Your Lordship. Respondent, Your Lordship. OA, Your Lordship.
You have also filed a writ petition. You are justifying the action of yours in appointing Ramna.
Yes, sir. Because same procedure has been followed in all divisions, Your Lordship.
But how can merit be compromised? Adi cheppandi.
85% has been taken for written marks, your lordship.
85% for written marks. Then
Written marks, 200 out of 85%, your lordship.
Huh?
Total marks for written test is 200 marks, your lordship. Wherein 85% has been considered, your lordship.
Correct.
Wherein the respondent in OA was got 41.65, your lordship.
41.65,
your lordship. The applicant got 43.78, your lordship. In interview, your lordship, 13.5.
Who has got 13.5?
Applicant, your lordship. Respondent in OA, your lordship.
Ramna's client.
Yes, your lordship.
13.5,
your lordship. And the respondent got 11 marks, your lordship. 11 marks, your lordship. Total marks, your lordship. 55.15, your lordship. 55.15 with regard to respondent the OA, your lordship. Prabhakar.
పేర్లు ఉన్నారు ఇక్కడ విలేజ్ చెప్పండి. ఆ రెస్పాండెంట్
Councils, Ramna councils.
రమణాకి ఎంత వచ్చింది టోటల్?
55.15, your lordship. Instructions it is provided, your lordship. In instruction. Yes, instructions also it is provided, your lordship. First para.
He'll be getting 45 marks, whereas this marks person will be getting 43.5. Yes, Ramna?
Yes. Return marks.
What happened is, committee Kanagaz Nagar, if I has given a goodbye to what is the circle is. Extra 15%, that took 15 marks.
This is in respect
That
of
is what is the find- no, that is what is the finding in the order.
finding. Selection committee is for 7 divisions, followed the same procedure.
Same procedure.
There is a finding like that, which has been given on the.
On that finding only, my appointment was set aside. But ultimately, what happens is, this procedure is followed for 7 divisions unanimously, not only in respect of my case.
It is very clearly stated in the order. Let me read. This procedure adopted in order to accommodate the fourth respondent and malafide intention can be inferred for the above circumstances. What else is required? The tribunal observation. We are not dealing with the facts. No, we are not going to the facts.
No, but I am not saying the matter, that's not the case. Here, I got, as per the 200 marks.
We are not touching your job. What we are thinking is, what is the injustice which has been done to them? That's all.
No, I am not saying anything, but what I am reading what is saying, this procedure is not only in respect of mine. There is the selection committee deviated from procedure, that is for all the divisions, not only mine.
A file material paper, your lordship, with regard to all divisions, your lordship. Unanimous procedure has been.
Correct, sir. Instead of adding 15%, you have
Taking
added 15 marks.
15 marks. your
అదే తప్పు కదా. 1 minute. For written examination, you must reduce it to 85%. Interviews 15%. But instead of
Percentage, your lordship.
computing on 15%, you have straight away awarded marks.
Marks.
That is wrong, kada.
But it is with regard to all divisions, your lordship, 7 divisions, your lordship, with regard to all selections, your lordship, not only with regard to.
Where is the selection procedure contemplated?
Your lordship,
Where is the
filed, your lordship.
notification?
Page 45, your lordship.
40?
45, it's.
There is a personal relation with circle level. All divisions participated. 2008-2009. Starts at page 43.
45 is the relevant, your lordship. Conducting interviews. Conducting of interviews, lordship.
Committee members and 46, page 40 is the resolution. All of them signed, all DFOs. Page 46, top paragraph. After completing all the procedures, marks taken becomes 22 into 15%. And finally, this will display the fraction of 2 digits by adding the Now, this is changed by DFO Kagan's Nagar, page 48. He makes it to 15 marks. That is found for with the tribunal, saying that
Supernumerary post state table.
With regard to other
One minute,
division,
1 minute. 1 minute, Peter Garu. Page number 46.
yes, sir.
After completing all the procedures, the marks secured in the written test will be computed to 85% and interview for 15%.
15%. And finally,
This you have violated.
Yes.
So, 1 minute, because of your violation, Ravichandran clients got
less marks.
less marks, karu. Injustice to him. On the same analogy, the person, Ramnath's client also, we can't say anything because entire procedure you have followed in all divisions. What to do?
7 divisions, the same process.
You create a supernumerary post, right?
2008, Justice B. Sudarshan Reddy's judgment in an education matter, they created a supernumerary seat for a student who wrote an examination where similar marks were considered. So, reason bench, 2008.
Randy, both these writ petitions are being disposed of by way of a common order. The issue raised in these two writ petitions is one and the same. What are those two cases? Item number cam 38 and 39. For convenience, the facts in writ petition number 26072 of 2013 are here under discussed. The writ petition is filed, agreed by the orders passed by the administrative tribunal in OA number 7275 of 2010 dated 30th July 2013. Right. కొంచెం మోల్డ్ చేస్తే అయిపోయేది ఆ రిలీఫ్ ని ట్రైబ్యునల్ దట్ ఈస్ రైట్ బట్ స్టిల్
Application of the certificate services for pay.
Yes, Jagapati.
I'm getting the memo.
What is that memo?
It is judgment in Ramana.
Kavada? ఇది ఆంధ్రప్రదేశ్ కదండి
One Telangana, one is EP.
Huh?
EP is capital, given order. 2% are value.
అవునా
I'll go through, Your Lordship. I think next week, Your Lordship.
ఓకే మన అల్లకి వెళ్ళి కదండి వాళ్ళకి సర్వ్ చేయండి ఇప్పుడు ఇవ్వండి సార్ అక్కడ లెట్ హిమ్ గో త్రూ దట్ పోస్ట్ నెక్స్ట్ ట్యూస్డే
It's the 100% 13 pension. Directed below.
రికార్డ్ ఇస్ దేర్ ఈ సినాప్సిస్ ఇది ఒక నోట్ లెక్క అని పెద్దది
సింగరం
పెట్టుకోను
Yes, Amar, what is this?
Lord,
He was exonerated of the charge and he says,
no, disagreed, my lord, on 5/2/2007 with the reasons. Subsequently, he has submitted his explanation. After considering the explanation, my lord,
no. When you have disagreed?
Disagreement, my lord, is on 5/2/2007.
When he was exonerated? Huh? Where is 5/2/2007? What?
5/2/2007, my lord. Page 66, my lord.
When you disagree after his retirement, that to 4 years.
What?
Just because he has filed a contempt, that doesn't mean that you should disagree on them.
Not that, my lord, there's a misappropriation of amount is there.
But the fact that it could not be proved in the inquiry.
No, not, is only preliminary inquiry, my lord. There was another inquiry by the officer.
Where is that inquiry?
Inquiry, the final inquiry report.
1 minute ఆగండి సార్. Where is the show cause notice 5, page number 60 అన్నారు కదా?
Yes.
కాదు 16
Disagreement, my lord, is 5 to 2007.
66.
That is at page 66. I may give the dates, my lord. It will be convenient if your lordship takes the dates.
1 minute.
Yes.
What is the limit for disagreeing is a question we are asking you. Can it enlarge the scope of rule 9 to this far?
No, they are, my lord, in continuation of if.
Right. Correct. 23/3/2003, he was exonerated. He has retired in June 2003. Correct. Only thing is, you are required to pass final orders. Correct. In pursuance with inquiries, report submitted on 23/3/2009. In spite of the fact that you don't, where is the charge memo first of all?
Charge memo 9/1/2003, my lord, at page 45.
9/1/2003.
3, my lords.
After 4 years of his retirement, where is the question of disagreeing? We are not able to understand. Up to 2007, you sit tight on those inquiry report. For next 4 years, you don't act. Only if approaches tribunal by filing OA number 3,400 in 2004 that came to be disposed of on 20/2/2006, you start disagreeing. This is not correct, no? When you don't comply that order, he has filed a contempt. Maybe that is a mistake he has done. Just because he has filed a contempt, that doesn't mean that you should disagree. Where is the material for you to say, for this reason I am disagreeing? There is no such thing also forthcoming, no?
No, that is available, my lord.
No, please see.
My lord, before this disagreement note, a final report has been given.
No dates. No dates in that. Reference third lot చూడండి, page number 66 లో. Third reference అన్నారు final report కదా?
Yes.
Date లేదు దానికి.
I'll give that final report, my lord.
ఇప్పుడు ఇచ్చారు Amar, when the show cause notice, disagreeing note itself is not having any date. How can you fill up that now? Come back to reference 3. Final report. There is no date. '66 Amar.
Yes. Lord.
66, page number 63. Reference third cited. చదవండి. Final report of GS Prasad Rao, IAS officer, Karimnagar, dated nil.
Report is available, my lord. Date is also available. Maybe he has omitted.
Why?
అదే ఫైనల్ రిపోర్ట్ ఇందాక నేను చెప్పింది ఇది డేట్
No, on these grounds, it has disagreed, Chalvandi. Page 67 law.
Yes.
MPDOs are empowered to sanction works
I
up
did.
to
I did.
1 minute, 2/11/2001.
Yes.
For the works sanctioned after the date 2/11/2001, MPDO is not the competent authority, right? You say yes, sanctioned some works after 2002, correct? And of the 112 works, 103 were verified, correct? Maybe some procedure lapses, but not misappropriation.
My lord, there is a huge loss. My lord, the collector report is given on 24/4/2006, according to which, my lord, there is a one
Not
crore,
like that,
1
sir.
crore.
1 minute, sir. If inquiry officer has submitted a report holding that the charge has not proved. No. You sit tight on that.
That's a provisional one, my lord. Subsequently, there is another report. That is what I am trying to submit.
Economy.
Initially, my lord, on 23/3/2003.
Okka nimsham, sir.
Yes.
1 minute.
Yes.
Come back to page number 66. This is a disagreement note you are giving, no?
Yes.
Disagreeing with the report of 23/3/2003 only.
Yes, my lord.
Mari?
Yes.
Earlier report entering me.
Kindly see, my lord. Paragraph 2, I read out, my lord, in that page 66. In the reference first cited, the project director, Water Management Agency, has examined the report of superintending engineer and found that irregularities have been committed by so and so. The district collector has appointed a district level officer and the case was entrusted to district level officer. He has submitted his report dated so and so in second cited, that is 23/3. A copy of inquiry report is enclosed. In the reference third cited, this is all. This is it. The Chief Executive Officer JP Karimnagar has conducted final inquiry and after examining all previous reports and documents, evidence.
Right, sir. 1 minute, sir. The third reference, Chief Executive Officer Karimnagar has conducted final inquiry.
Yes.
And after examining all the previous reports and documents, evidence and submitted his report.
Yes.
A copy of the final report is enclosed on. Correct. Thank you very much. That final third reference cited, the reference లో చూడండి date లేదు.
Here date
1
is
minute. Which is earlier? 23/3/2003 is earlier or the third reference is earlier?
third reference is the third reference is the latter one. The first one is the earlier one.
Correct. Then come back to 67, para 6. Then why you are disagreeing when it is already final inquiry is submitted in third reference cited? Why you are disagreeing with 23/3/2003?
After that, paragraph 5 of such.
Chadvan.
In the reference 6 cited, the collector Karimnagar has reported that a total quantity of rice misappropriated by the individual
అది ఎప్పుడండి
is arrived.
1 minute said charge memo is at page number 45. దీనికి ఎంక్వైరీ రిపోర్ట్ ఎక్కడుంది ఈ చార్జ్ మెమోకి?
23/3 ఫస్ట్ చూడమ్మా. ఫస్ట్
Amar, all is not well. Because ఆలోచన చేయండి. Look into the papers once again. Because page 45 is the charge memo. Page 55 is the final inquiry officer's report. It starts at page number 48. He says, after following rule 20 of CCA rules, he has submitted this inquiry report, holding that the charge has not proved. 48 law. Right? Kind attention. Chadandi, page 48.
Yes.
Kind attention is invited to the.
I have conducted departmental inquiry against charged officer and so and so.
Submitted a report.
Inquiry report.
So, based upon subsequent developments, can you disagree? Is a question, Amar, please. Based upon a report alleged to have been submitted in 2006 by the district collector, you are trying to disagree, which is not permissible. ఇక్కడ చూడండి disagreement report లో all these documents which are referring to 3, 4, 5, 6, they're all subsequent to conducting of inquiry. కదా? So you cannot disagree with us based upon some certain documents which are furnished after the inquiry. Otherwise, you should have ordered for de novo inquiry. Disagreeing would not arise, no? Right? You can order de novo inquiry because these are the materials which could not have been gone into by the inquiry officer. We set aside these inquiry officers and direct the inquiry officer to conduct de novo inquiry. But the question of disagreeing based upon the material which is there after inquiry officer submitting a report, it is not permissible, right?
Yes, my lord, in fact, in this case, rules were not strictly
We are not on that.
adhered to while conducting the discipline. I could notice, my lord, but the point is that whether if there is lapse on his part,
He may be having, we are not saying that he is saint. We are not saying he is good. We don't know anything. Whether legally we are examining the case, when once inquiry officer submits a report as holding as charge not proved, based upon subsequent material, can you disagree with the findings of inquiry officer is a question, which is not permissible. At best, these factors were not considered by the inquiry officer. That's the reason we direct the inquiry officer to conduct de novo inquiry. That should be the stand of state, Kadandi. How can it disagree? Correct?
your lordship, my lord, I only request your lordship, my lord, if the
మూడు చార్జెస్ కరెక్ట్ ట్రైబల్ ఏం చెప్పి
Okay, writ petition is filed.
Lord, your lordship, sir,
Allowing.
Lord, there's a,
Huh?
I'll argue the matter. If your
Huh?
lordship's not direct them to reconsider the punishment,
No.
100% cut in pension.
No, no.
Otherwise, my lord, I'll satisfy your lordships tomorrow. Straight away allowing, my lord, this is 20 years ago case, my lord.
Maybe.
If your lordships allows, there's a, already
Go
there's
by
a
the law, sir. We
huge
go by
law,
the-
no, there's a revenue loss to the government.
Maybe. You should have been, you must be more careful then. 1 minute again, sir. చెప్పండి మరి చెప్పండి.
Lord, on the point, whether on 5/2/2007, a dissent note was issued that is based on subsequent, the subsequent issues, they have issued dissent note. That is what your lordships were asking.
It is a fact.
No, in fact, my lord, it's a continuation, my lord. It's a continuation of the, after retirement, my lord, matter will be sent to the government, my lord, for passing appropriate orders.
No. Everything has to be in accordance with law.
Yes, my lord, I'll satisfy your
It
lordship.
should have ordered for de novo inquiry.
Tomorrow, my lord, I'll satisfy your lordships on that point. So I'll argue the matter on merits. Your lordship may pass appropriate.
ఏమైతే సార్ ఇవాళ
No, 100%, 1 crore rupees, my lord, there were collector misappropriation is there, that cannot be allowed, my lord. My submission is if he gets some, if he gets some,
sir, don't try to prejudice us about financial issues. We'll go by the law. Inquiry officer has submitted a report while he was in service, exonerating of the charges. After inquiry officer's report, he has retired after 3 months in June 2003. You grant provisional pension. He files one OA to conclude the disciplinary proceedings by taking into account the inquiry officer's report. OA is disposed of. You don't comply that order. He files a contempt. That is a real issue now for you. Now you issue a dissent note in 2007 saying that we are disagreeing for the reason this district collector has submitted a report in 2006, some other officer has submitted a report in 2005, some other officer in 2003. These factors were not available before the inquiry officer. Where's the question of you disagreeing? That's the point.
Very well, my lord, I'll satisfy your lordship
Can satisfy.
tomorrow.
Mali ade cheptu.
I'll argue the matter.
Because we are hearing, you know.
Yes, my lord.
Mali.
My submission is, my lord, if
If a government feels that inquiry officer has not taken into these things into account, it should have ordered de novo inquiry.
Lord,
Kada?
yes, Lord. Prejudice aspect, your lordship may also kindly
Em
appreciate.
prejudice ante. Mere prejudice.
Lord, no. The reports are given by the Lord district authorities. District collector has given a report.
So what, sir?
Very
District
well.
collector he is above law, na?
Not that, my lord. While deciding the issue, Lord, those things were referred. And if
Sir, today I give one judgment. Let us say inquiry officer has given one judgment saying that charge is not proved. No. These factors, subsequent factors also, tomorrow it is likely to rain, or day after tomorrow it is likely to snow, or all those things. That's the reason I disagree with the inquiry officer. And how absurd it is.
no, my lord, yes, what your lordships, I got that point, my lord. Tomorrow, give me one chance. I'll argue the matter before lordship. I leave it. I'll not stretch much further, my lord.
Come back to page 66.
Only on the point.
Come back to page 66 and 67. These are the reasons we are disagreeing. All the communications are of 2000, after 2003 only.
Yes.
For events which have happened subsequent to furnishing of inquiry officers report, how can you disagree?
That's a continuation of the under rule 9. Under rule 9, my lord, disciplinary proceedings can be continued even after.
Thank you. That much we understand, sir.
Yes.
Don't you think that we are not aware of rule 9?
No. Yes,
Yes. Come back to tribunal goes in one particular direction, but suddenly slips away. Page 28, rule 21. Read of CCA rules.
Yes, rule C. Yes, I'll read.
It travels half of the judgment in a right direction, gets slipped away based upon your reasoning given. Rule 21 చదవండి sir.
I'll read.
Nice, behind man. Struck करके.
May I read this, Lord?
Yes.
The disciplinary authority, if it is not itself the inquiring authority, may, for the reasons to be recorded by it in writing, remit the case to the inquiring authority for further inquiry and report, and the inquiring authority shall thereupon proceed to hold the further inquiry according to the provisions of Rule 20 as far as may be. The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority together with its own tentative reasons for disagreement, if any, with the findings of inquiring authority.
Yes.
With the findings of inquiring authority on any articles of charge to the government servant, who shall be required to submit, if he so desires, his written representation of submission to the disciplinary authority within 15 days, irrespective of whether the report is favorable or not to the government servant. The disciplinary authority shall consider the representation, if any, submitted by the government servant and record its findings before the proceedings further in the matter as specified in sub rules 4 and 5 below. If the disciplinary authority, having regard to its findings on all or any of the articles of charge, is of the opinion that any of the penalties specified in clauses 1 to 4 of Rule 9 should be imposed on the government servant, it shall, notwithstanding anything contained in.
Okay, you are asking for tomorrow, right? Tomorrow, na? You will not believe in August. Right?
And separate quotation, if I have a testimony.
Yes.
Versus this is the evidence that is charged. We will find it in the actually so. The findings given by the picture was 65 to 67.
ఒక నోట్ ప్రిపేర్ చేయండి సార్ పోస్ట్ ఆఫ్టర్ 2 weeks. నోట్ అంటే పార్ట్ చేసాను. Yes, sir. Yes. We are not able to hear you, sir. You appear in person and argue the case, post after 2 weeks.
Sure. Super Boda Ramadashmi Pari Praveen Finance.
Yes. Post after 2 weeks.
This is Pari Praveen Finance, which one in there?
Yes. Where is Anurag? Post after 2 weeks.
This is Seven Rashmi Parot Fergaji, Indian Micron now.
Next week.
Post after 2 weeks next.
See 8 PV Ramana, Mandana Sriram.
Yes.
So retired employee, personal capital pension. Third analysis.
Who is your other side, sir? Ready, sir? Yaka ready? Post after 2 weeks next. Yes, Advocate General. Post after 2 weeks.
Getting the made evaluations for the very higher qualification of GOMS but the important additional working as well as
That study leave should be given. Same case, no? 342. By following some orders, it was allowed. By following orders passed in 7182 of 2012, case is allowed. Is it covered? What, sir? అది ఇంప్లిమెంట్ చేశారా 7182? Have you implemented 7182? Post after 2 weeks next. SC/ST కి ప్రమోషన్ కి ఒక క్వాలిఫికేషన్ ఉందండి. వాళ్ళకి స్టడీ లీవ్స్ ఇచ్చి salary కూడా pay చేస్తారు. In order to acquire that qualification, so as to enable them to acquire that qualification, it's promoted. For 342 due allowance. First after 2 weeks, next. 2 weeks. Next. 2 weeks.
74 days sitting for agriculture.
2 weeks.
75 cases there are services on.
2 weeks.
Still Jagadish services on.
2 weeks.
7 soda Vandana services on.
2 weeks.
28 Rama
Standing next to it.
2 weeks, next. Same thing, right? 2 weeks. Yes, 2 weeks.
Next week.
Two weeks, next.
Next week.
2 weeks. 2 weeks. Yes, 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks. Creamy layer. First after 2 weeks, right?
on 16 and 17, no? This morning. Both settlement was posted finally, but thereafter another 4 days have taken place. The other side is not.
Oh.
There is a initiative there.
It is in advanced list. When do you want? Okay, wait, any next week, Thursday. That 116, 17, I think they might come tomorrow, sir.